Good afternoon and welcome to DCR's presentation of Licensing 101. We will just be beginning in a few minutes. We're going to give folks another minute or two to hop on before we get started, and then I'll go over what the presentation for today is going to look like. Thank you for your patience. Good afternoon. My name is Jason Colleen, and I'm an Assistant Executive Director with the Department of Cannabis Regulation. Today, we're going to do a Licensing 101 session where we cover different pieces of the local licensing process and application processes. Throughout the process, we've broken it up into 4 one-hour modules. I will do a brief PowerPoint presentation. We will take a 5-minute break. Then we'll go ahead and get into the pre-submitted questions. And then we'll get into any questions that are asked as part of the module process. Then we will take a brief 5-minute break between the next module to then give folks the ability to come on. So the training was designed with the intention of giving folks throughout our licensing process the opportunity to come in and learn new things. Prospective applicants, of course, are going to want to know everything from the beginning, and folks that already have licenses are probably more focused on the environmental review and how do they get their annual license. So we've designed it in a way that folks can come in and kind of jump in and out as needed so that they can learn new information. So welcome. Right now, I'm going to go ahead and go through the agenda. As I mentioned, we've got it broken up into 4 one-hour modules. So the first part of the presentation is going to focus on the dual licensing requirements, the different license types that folks can apply for, the DCR's licensing portal, how to register for an Excella account, which is to access the licensing portal, how to set up a business tax registration certificate account with the Office of Finance, how do you create a legal business entity record, what does the equity share review process look like, different fees, social equity program resources, and then various state and city deadlines. Then we'll jump into a Q&A session. For the second module, we'll be covering the pre-application review process. We'll be going through the different location compliance related information from LEMC section 105 and sensitive uses. We'll go through the pre-application review workflow. We'll review some of the forms. We'll talk about ineligible locations, different sensitive use restrictions. I'll do a brief presentation on the zoning information map access system so folks can better understand how we do measurements and how we look at land use related information. We'll talk about some of the fees and the waivers that would be available, social equity program resources, and again, state city deadlines. Then we'll get into the Q&A. For the third part of the module, we'll go through the temporary approval application process. We'll go through the different procedures and bulletins, the documents and forms that are needed for the application, what the fees are, again, social equity resources, and then the state and city deadlines. With the temporary approval process, we really streamlined it last fall under the direction of our new director, Michelle Garakian, where we took out the business-related piece and we put it in the legal business entity record so that once the information had been vetted, we wouldn't have to re-vet it anytime a new application was submitted. And then, of course, that reduces costs for applicants and licensees, as well as gives them the opportunity to only have to modify those records and that information when it changes. So that was a big efficiency that she brought to the table and got implemented. And now we're starting to see the fruits of that labor. And then the last hour is going to be a discussion of the annual licensing process, the California Environmental Quality Act, the DCR's Form 4013, which is what we use to determine whether or not a project may qualify for a categorical exemption, how to use ZMIS to get information to fill out your Form 4013, the different fees that are associated with it, the SEP resources, and then of course, upcoming state and local deadlines. And then we'll get into the final Q&A of the night. So to kick off the first module, I'm going to talk a little bit about the dual licensing nature of commercial cannabis activity within the state. So a commercial cannabis business must have a local license. Locally, the Department of Cannabis Regulation issues licenses on behalf of the City of Los Angeles. And a business also has to have a corresponding state of California Department of Cannabis Control license. Even if you have both of those licenses, you still have to meet all other local, county, and state permitting requirements. Building requirements, fire requirements, public health requirements, occupancy requirements, et cetera. Since each jurisdiction has its own sets of rules and regulations, we're really going to focus today's presentation on just the city's requirements. Currently, the City of Los Angeles is accepting applications for non-volatile manufacturing, distribution, and testing laboratories from all applicants. The non-storefront delivery application is accepted from verified social equity individual applicants. Applicants that were either verified in 2019 or 2022 have the ability to submit a non-storefront delivery application. We are not currently accepting applications for the cultivation activities. We plan to administer a future lottery to allow for folks to participate in a lottery for the remaining cultivation licenses that may be pursued within the city at a later date. Certain social equity individual applicants have been selected through our phase 3 retail round lotteries. We administered the round 2 lottery last December, and those folks have the opportunity to submit a pre-application review record. And if their business premises is eligible for further processing, they have the ability to then submit an application, whether it's a temporary approval application or an annual application. And we plan to administer an additional lottery later this year to give additional SEIAs the opportunity to apply for the retail storefront activity. And we have not begun accepting applications for volatile manufacturing from any group yet. So new applicants are going to have to make sure that they've registered their online account through the DCR licensing portal. Any contact, whether it's an owner, primary personnel, or other contact that goes on a record, has to have an account through the DCR licensing portal. Additionally, if you're pursuing a license as a business entity, anything other than sole proprietor, you'll have to get your federal employer identification number from the IRS. And that's one of that's a piece of information that you'll need in order to register an account for your legal business entity, as well as register for your business tax registration certificate with the Office of Finance. So if you are planning to create a corporation or an LLC, it is important to make sure that you've registered that entity with the federal government as well as the California Secretary of State, so that you can have the appropriate entity numbers for your entity to provide to our local agencies, DCR, the Office of Finance, as well as state agencies, the California Department of Tax and Fee Administration, as well as the California Department of Cannabis Control. Then, of course, once you have your numbers, you'll be able to register for an Excella business account. And then from there, you can create your legal business entity record. So navigating the licensing portal. Once you've navigated to DCR's website, you have the ability to go to the DCR licensing portal. And we have the link here, and links will also be provided at the end of the presentation. When you get into the portal, you'll have an option to create an account. You can see there's a button down at the bottom of the screen, as well as register to apply for a license. That'll give you the opportunity to register a user account. So you as an individual will want to make sure that you have your individual account and you're assigned your individual ACA reference ID number before you go ahead and go in and create one for your business entity, just to make sure that your information You have your information as an individual and you have the information for the business entity. When you create your individual account, you'll create a user name, a password, you'll assign it to an email address. The email address has to be unique. It can't be used for any other account within the portal. So if you have a business email address that you want to use for your business entity, you're going to need to make sure that you associate that email address with the business entity, and you either have a separate email address or a personal email address that you associate with your individual user account. Once an email address has been associated with a given profile for login purposes, it can't be reassigned to another user account without deleting one of the accounts. And DCR is the only personnel that has the ability to remove accounts. And to date, we really don't remove any accounts unless they're test accounts. So please make sure that you have the correct email addresses when you go to create your individual accounts. It'll ask you to select a security question and answer. You'll be asking whether or not you're creating an individual account or an organizational account. The organizational account type is for business entities. And then, of course, you need to know your first name, your last name, your social security number. You'll have the ability to provide a primary and secondary phone number, your date of birth, email, and your mailing addresses. It takes about 3 minutes to create an account. Once you've populated the information, you can navigate to the My Account option, and you'll be able to see what your ACA reference ID is. It's a unique 9-digit code tied to your user account. This information is important for when you submit either a legal business entity record or you submit an application record, because when contacts are assigned to those records, there's a lookup function, and the only way your user account will be associated with that record is by having the ACA reference ID input as part of the record intake process. And then, of course, making sure that it's selected and then you're assigned to the appropriate role. Now we're going to jump into the business tax registration certificate and legal business entity process. You'll commonly hear DCR personnel refer to it as BTRC or LBER. So all individuals and entities conducting business within the city of Los Angeles are required to register and apply for a business tax registration certificate through the Office of Finance. Prior to the creation of the Department of Cannabis Regulation, City Council adopted a policy that prevents the Office of Finance from issuing business tax registration certificates to non-identified commercial cannabis businesses. So in order to get a business tax registration certificate for a commercial cannabis business, you have to go through the Department of Cannabis Regulation. If you apply directly with the Office of Finance or through their online portal, you may be assessed a business tax registration certificate number, but when they do their audit and identify that you're a commercial cannabis business and your business didn't come through DCR to the Office of Finance, the account will be closed. And that creates headaches for folks because they start to use this number that's not actually registered for a commercial cannabis business within our portal, and it could lead to a duplication of effort. So it's really important that if you're registering your BTRC for the first time for your business entity, that you follow DCR's instructions and you go through DCR. This number is really important because it allows DCR to communicate with the Office of Finance to make sure that any fees that are due have been assessed to the correct taxpayer and DCR accounts. And it also makes sure that the Office of Finance has knowledge that your business is either applying for or has been registered to conduct commercial cannabis activity within the city of Los Angeles. The business tax application form is what's used to apply for a business tax registration certificate. The form is available on DCR's website as well as the Office of Finance's website. If you are completing this form for a new commercial cannabis business, you need to make sure that you submit it to DCR licensing at lacity.org, Once the form has been emailed to DCR, we provide the form to the Office of Finance. We notify them that you're a prospective applicant in our process, which gives them the authorization to establish a BTRC account for your entity. Once they've established the BTRC account, which takes normally 3 to 5 business days, they'll email the information to DCR, and then DCR will forward the information on to you. You do have to have a BTRC number in order to create a legal business entity record, so you need to make sure you get this first. You do have the ability to register a BTRC to yourself as a sole proprietor, which is then linked to your Social Security number. So if you are planning to go through the pre-application process as a sole proprietor, you can register for a BTRC as a sole proprietor, utilize your Social Security number instead of a federal employment identification number, and then we can issue you your BTRC number that you can then use for your application as a sole proprietor. Everybody who is applying for or plans to pursue a commercial cannabis license does have to have a BTRC. It doesn't matter if you're an individual sole proprietor or you're a corporation. Both will need to have their own unique BTRC. So the way the flow for the registration works is requests come into DCR, we review the request, we forward it to the Office of Finance. The Office of Finance reviews the form, and then they issue a BTRC number, and then DCR communicates the BTRC number back to the requester. For the BTRC, there's 3 things that are very important. The first is your federal employment identification number. That's a number that the Office of Finance links to your local taxpayer account in their system and for your legal entity. The second piece is the entity number that is issued by the California Secretary of State. Finance may be able to set up a BTRC account with that information or without that information and without the seller's permit number issued by CDTFA, but you will need to provide that information before you're able to engage in commercial cannabis activity. The need for that information is really based on what the Office of Finance has in their system and where you are in our process. We do recommend that you have those 2 things first so that they can complete your taxpayer account and that we have all of the numbers necessary to talk to the state of California, the Department of Cannabis Control, the Office of Finance, or other, because these are kind of those universal numbers in addition to the BTRC that different agencies use. And when we have to talk to those agencies, we want to make sure that we're talking about the same business entity or applicant. So it is important to make sure we have these numbers on file and they're consistently communicated to all of the different agencies that may be helping you out at the local and state level for your license applications. So once you have your BTRC number, you can go ahead and create your account for your business entity. Again, it only takes about 3 minutes to create these accounts. You'll go ahead and create a username for the business entity. It needs to be different than your personal account. You'll create a password. You'll have to select an email address. It will have to be different than the one used for your personal account. And then you'll be able to create a security question and answer. You'll be asked to identify the name of the business, the email for the business. It has to be different than what's used for your individual account. Identify the phone number, the federal employment identification number, and the mailing address for the entity. Then, of course, once you've registered your user account, you'll have the ability to log in and go to My Account. You can see basic information associated with your account, as well as your unique Excella Citizen Accents reference ID number for the business entity, which you'll need in order to create your legal business entity record, as well as, as you move forward in the application process, as you're creating additional records, you're going to want to make sure that you're applying under that business entity, not yourself as a sole proprietor. So for creating the legal business entity record, it's a new record that was established last fall under the direction of our director in order to streamline the application process, as well as acknowledge that the ownership for one application for a business entity should be the same ownership structure and review as any other records or applications submitted before a DCR. So what we did is we created a standalone record that allowed for the business entity, the owners, the primary personnel, and the key contacts to be vetted outside of the application process. This allows for us to do a review of the entity in advance of an application getting submitted, which means that it will be a quicker turnaround time for reviewing and processing your application. It also allows DCR to do the equity share review for social equity records without having to have an application before it. So this gives a social equity applicant the ability to establish their business entity, identify the owners and primary personnel, go through the equity share review before they even submit an application, so that they have peace of mind that once an application is submitted, that work has already been done, and it should be a shorter holding period between the time that they submit the application and at the time they are eligible for either temporary approval or a notice of a complete application for the annual application process. The goal and the director's goal has been to reduce processing times, which will ultimately reduce the holding times that applicants have to be paying rent and engaging with other agencies before they get some kind of final determination and they have peace of mind to move forward in the process. So we'll kind of discuss that a little bit more in detail as we get into the different application processes. But there has been some questions from existing applicants about why they have to register the legal business entity record, how is it pertinent to them? And this was a requirement as part of the 2023 renewal process to make sure that every applicant and licensee has this, because this record will be necessary on a go-forward basis, not only for the annual application process, but all future applicants coming into our process. One record is required for each business entity that is either seeking to apply for, has an application pending, or has been issued a license. Again, this streamlines the overall process for applicants, licensees, in the department. These records do not have to be renewed annually. So by taking this out of the application, it actually reduces the renewal fees, which you'll see in our upcoming 2023 fee study. These records can be amended on an as-needed basis. So if ownership changes before a license is issued, you'll have the ability to request that change on this legal business entity record, and it won't affect any pending applications before the department. And of course, the legal business entity record will act as a parent record for all of the application and licensing records that are owned by the same legal entity. So it makes managing and reporting information a lot easier as well. So this is kind of the way it works, is your legal business entity record is going to be linked to your unique 9-digit Excella Citizen Access reference ID for your business entity, the 10-digit business tax registration master account number from the Office of Finance, and then the state of California information, your Secretary of State information, your seller's permit information, et cetera, so that no matter which agency we're talking to, we have a unique identifier tied to your business entity that they will have in their records, so that we can ensure that we're communicating about the same legal business entity. And kind of the way it works is the legal business entity is the umbrella over your business location and any of your unique activities that are either tied to that location or any other additional location that you may have within the city of LA. In terms of the application information forms required, these forms were all previously required as part of the temporary approval application process. And what we did was we pulled these out of that process and put them onto the legal business entity. So now the primary personnel and owners list, the attestations, the ownership and financial interest holder forms, the financial information forms, and then for our social equity businesses, the owner compliance attestations, that will all live on the legal business entity record, and those documents only have to be amended or modified if there's a change to ownership, primary personnel, or financial interest holders. Otherwise, the information will just stay on the account as is until it needs to be amended. An overview of the forms is we've got a list of primary personnel and owners forms. You'll put the name, the title, role of the individual. You'll identify, if they're an owner or if they're a primary personnel. By definition, every owner is also a primary personnel, which is why we have the two radio buttons next to each of them, because any owner, it should be an owner check and a primary personnel check. That person may or may not actually have a formal role within the entity, but owners are considered primary personnel. We've got the different attestation forms, which is effectively having the individual attest that they have the ability to either be an owner or a primary personnel of a City of Los Angeles business, and that they have not been convicted of different criminal offenses or other things that would preclude them from being listed as an owner or primary personnel on the record. DCR does not do live scan checks. We did remove that from our process because one, it's duplicative of the state's application process. And then two, it also increases the processing times for the city to be doing the live scan for all of the owners and primary personnel on a business entity. So to make sure that our process was as streamlined as possible, and with the understanding that the state does live scans as part of their licensing process, the city only requires you to submit an attestation to be an owner or primary personnel for a commercial cannabis business as part of our application and licensing process. We also have the ownership and financial interest holder forms. That's where you're going to disclose information about folks that may not have an equity stake that rises to the level of being a capital O owner. So folks may be an owner, a lowercase o owner of a commercial cannabis business, and have an equity stake between 0.01% and 19.99%. Once they have a 20% or more equity interest, they're considered a capital O owner. So this form is really intended to allow you to disclose folks who have an ownership or equity stake in the entity that is below 20%, because there are going to be times where we need signatures from a simple majority of the owners, and you may have to disclose some of the folks that are below 20% just for us to be able to get to that 51% threshold. So, it is helpful for you to disclose as much information as possible, just because it makes processing the application or any modifications necessary for the application easier when we have more information, because then we don't have to get you to fill out the forms at a later date. The other piece is going to be to identify what types of investments, loans, and funds the applicant is getting before we issue a license. And then, of course, having owners of social equity businesses identify that they're going to adhere to the requirements under Los Angeles Municipal Code Section 10420, which regulates our social equity program. Once you've logged into your account, you can navigate to activities and then apply for a license. You'll go ahead and read our general disclaimer and accept the terms, and then click continue. Once you've done that, you'll be presented with the ability to create different record types. So you'll go down to the legal business entity application. You're going to be asked whether or not you're a sole proprietor, yes or no. If you are not a sole proprietor, you will provide the Excella Citizen Access Reference ID number for your business entity. And remember, when you're logged into your business entity account, you can get that under your account management tab. Are you going to request equity share review? If you want your business to be identified as a social equity business, or you're going to be applying for an activity that is limited to social equity applicants, you have to request the equity share review. If you do not request the equity share review, the account associated with the business entity will not be cleared to apply for non-storefront delivery, cultivation, or any of the other activities that are limited to social equity applicants. So it is important for you to select the equity share review when you create the record. If you don't select it, only DCR staff in the back office will have the ability to workflow the record back to the beginning of the process. to allow for the record to go through the equity share review and for the business entity to be identified as a prospective social equity business entity. Then, of course, you have to have your business tax registration certificate number. The master account is the first 10 digits of that number. It always starts with 3 leading zeros and then 7 random digits assigned by the Office of Finance. And then you have the ability to designate whether or not you want to put an authorized agent on your record. An authorized agent is a primary personnel of the applicant or licensee that has the ability to sign and submit forms on behalf of the applicant entity. And it does reduce some of the signature requirements for some of the forms. So this is what the page looks like. I'm highlighting the BTRC master account number because this is going to be the first 10 digits of the number assigned by the Office of Finance. It will always start with 3 leading zeros right now, followed by 7 random digits. After the first hyphen, through the end of the BTRC number, that's a number associated with the location for a given permit or activity. So for DCR's purposes, those numbers don't matter because when you actually do have an application pending tied to a location, that's the time at which we would use the full 15-digit number. Because if your business has multiple locations or you're applying for multiple commercial cannabis activities, the last 5 digits of the BTRC number will always be unique to that location. The master account, though, is always going to be the same, regardless of how many locations or your business is associated with within the city. After you've answered the basic questions, you'll have the ability to add contacts to the record. You can click enter information. My preference is to use the lookup function. When you use the lookup function, it'll ask you for the ACA reference ID of the person you're trying to add to the record. And then once you've entered that number, it will give you a list of options for what their role is. And then you have the ability to select the different contact types. Once you're finished adding all of the contacts, you click continue. Then you have the ability to upload the documents and information that are required for a legal business entity record. If you need to edit anything, you can go ahead and click on the add button again and just override whatever file you selected. Once you've clicked continue there, you'll have the ability to review your legal business entity submission. You can look at the different responses to the questions asked. You can look at the different contacts that have been added to the record. You can look at the documents that you've uploaded, and then you'll read the certification statement and then agree and then click continue. It'll show you the fees. If you do request equity share review, the fee to conduct the equity share review is $1,248. If you do not select equity share review and your record needs to go through equity share review at a later date, then of course, you'll have to pay the $1,248 and it will delay application processing for you. So if you know you got to go through the equity share review, it's best to go through it early. Fees do get assessed automatically by the system. So if you're a social equity applicant and you're eligible for a fee deferral or a fee waiver, DCR does have to go into the record and review it and then make the appropriate changes and notations on the record. But we can only do that after it's submitted. So for instance, our phase 3 retail round 2 applicants, they're eligible for fee waivers for the equity share review, reviewing the legal business entity record, the pre-application review, the temporary approval application. But only once they've submitted those records can we go in and verify that they are eligible for the fee waiver and then go ahead and delete the fees from the record. So if you submit a record, it will add the fees, it'll generate an invoice. If you know you're eligible for a fee waiver or you have a question about whether or not you're eligible for a fee waiver or fee deferral, please reach out to staff before paying the invoice because once you pay the invoice, the best DCR can do would be to request that the Office of Finance credit your taxpayer account and then you can use that credit for future fees or to pay any tax obligations you have. So if you have questions, please feel free to reach out to the department during normal business hours, Monday through Thursday, 10 a.m. to 3 p.m. via phone, or email dcrlicensing@lacity.org. So just, I'm going to do a quick overview of our social equity program and some of the tools that are available to assist social equity entrepreneurs. So, we're committed to promoting equitable ownership and employment opportunities within the cannabis industry. The goal of our social equity program is to decrease disparities in life outcomes for marginalized communities and folks that were directly impacted by the war on drugs. One of the components of the social equity program is the ability for social equity applicants and businesses to get business-related assistance, as well as ensure that the business does meet the equity share provisions described in the municipal code, which are under 10420. Prior to issuing a license to a social equity business, we may have to conduct an equity share review. We are required to do the equity share review for everybody other than phase 2 applicants before temporary approval is issued. And of course, for the phase 2 applicants, they'll either have to go through an equity share review if they're tier 1 or tier 2. For the tier 3 businesses that are not identified as being social equity businesses, they have to enter into a social equity agreement with the city and then submit that as part of their annual application. Social equity individual applicants generally need to own at least 51% of the business entity as part of the phase 2 process and phase 3 retail round 1. Folks did have the opportunity to apply as a tier 2 applicant, which means that they only had to have 33 1/3% ownership within the business entity. Businesses do have an ongoing obligation to comply with the equity share requirements, so it's not a one-time thing. Once we've completed the equity share review, it's tied to the owner's primary personnel agreements, operating agreements, bylaws, everything tied to the legal business entity. So if you are doing a modification to your legal business entity record, it may require DCR to do another equity share review to ensure that your legal business entity continues to comply with the requirements under 10420. There's various different filing fees. As you can see here, there were different fees for the temporary approval application process. The folks that went through the temporary approval application process under phase 1, under phase 2, under phase 3 retail round 1, different fees for general applicants, different fees for social equity applicants. So in order to streamline everything, our new director has given us the mandate to basically ensure that the temporary approval application fee is consistent for both general applicants and social equity applicants, which will reduce the cost for social equity applicants. And then for us to do the review for equity share on the legal business entity record as a one-time review until such time that the ownership or primary personnel of the entity change, which may necessitate an additional equity share review. But we can review those changes and modifications on a case-by-case basis to determine whether or not the change is sufficient enough to trigger the equity share review. And she's done all of that with the intention of reducing barriers to entry for social equity folks and then streamlining the fee structure. So that's one of those big changes that you guys will be seeing a little bit later in 2023. In terms of our social equity program, the social equity team led by Dr. Amani Brown engages in business licensing and compliance assistance. They are managing a learning management system or LMS. There's over 140 hours of educational content and webinars that are already on the LMS. There's the pro bono, low bono legal assistance. There's one-on-one coaching offered by vendors. They have a job board. They're starting workforce development, and they just closed out the Seed 2.0 grant program at the end of March. as additional grant monies that can be provided directly to applicants and licensees in the form of financial assistance becomes available, they will be opening additional rounds of the seed grant program. So there's a lot of tools and resources that Dr. Brown and her team have been putting together to assist social equity entrepreneurs. In terms of the upcoming deadlines, June 30th is the last day for the Department of Cannabis Control to issue provisional licenses, and applications that are abandoned on or after June 30th, 2023 are going to have to be submitted as annual applications unless you have an active corresponding state provisional license. And then I'll get into some of the other dates as we get into some of the other modules. So with that, we do have some links to our state Department of Cannabis Control that can be used as resources for licensee. I'm not going to go over their process because it is their process and it does change. And then we're going to go ahead and take a quick 5-minute break, and then we're going to reconvene for the question and answer session. So I look to start back up on the Q&A around 3:47. So if it's muted and you're coming on, just know that we are getting ready to do Q&A. So I'm going to go ahead and look at the questions that were asked during the module, and then we'll jump right into answering them. So please bear with staff as we get these questions added to the list. Thank you. I think we're ready to hop into the Q&A part of the presentation. We will answer as many questions as possible, then we'll take another brief break before we start the second module. So I'll turn it over to you, Gidget.
Good afternoon, everyone. Thank you, Jason. And we'll start with the first question from Roberto L. Is a cannabis lounge legal in the city of Los Angeles?
DCR has not begun accepting applications for or issuing licenses to business seeking to allow for on-site consumption, so not at this time.
And then our next question comes from Deirdre H. Is the application process still open to all social equity applicants, even if there's not been an application submitted yet?
Verified social equity individual applicants have the ability to submit social equity applications for non-storefront delivery, distribution, manufacturing, cultivation processor, nursery, testing labs at this time. We do intend to open up the verification process to new social equity individual applicants later this year, as well as hopefully conduct another lottery for the retail storefront opportunity in the near future.
Okay, Jaime S. asks, are unincorporated areas of LA open to licenses?
So DCR only has jurisdiction over the city of Los Angeles. The county of Los Angeles is working on its own cannabis licensing program. So I would recommend that you check their website to see where they are with their process and program.
Okay, thank you. Our next question from Rick J. For a new distribution permit, do I need an approved cannabis CUP and or a new certificate of occupancy?
So DCR doesn't issue CUPs, but if you're applying for a new distribution license, you would have to submit an application to DCR. And depending on your proposed location, you may need to get an updated certificate of occupancy to cover that activity type. In regards to the certificate of occupancy question, the Department of Building and Safety is the agency that reviews those change requests, and they would be best positioned to let you know whether or not you would have to change the C of O if you did pursue that activity at that location.
Our next question from Dasjul Z. Will consumption lounges licenses be on the table?
DCR hopes that the City Council will adopt policies around on-site consumption and then allow DCR to begin accepting applications and then implement that application process consistent with what those policy decisions are.
Thank you. Philip F. asks, when are applications being accepted again, and when is the application portal open again?
So the application, the DCR licensing portal is still open, and really whether or not you can submit the application is depending on what commercial cannabis application type you're applying for. So a little bit earlier in the presentation, I ran through which type of commercial cannabis activities we're accepting applications for, and then which ones are limited to social equity individual applicants. So that will be available as part of the presentation later on.
Perfect. Fern W. asks, I want to know how long it will take for me to open up a shop, and I need an investor to help me open up the shop, and I need a location. Please help me.
So I would recommend if you're a social equity applicant, reaching out to the social equity team at dcr.sep@lacity.org. And then they can run through the different services that may be available to you as a social equity applicant to provide you business licensing and compliance assistance.
Thanks, Jason. Our next question from Karan M. If I had already been verified in the past, what should I do next to help my process in opening up the business?
Yeah, if it's related to verification for the social equity program and you're a verified social equity individual applicant, I would, again, recommend reaching out to the social equity team so that you can get more information on what programs may be available to you that would help you in pursuing an opportunity in the cannabis industry.
Lavon E asks, are there any updates as to when the mayor will sign the approved February 16th LADCR report?
So the mayor approved the council action which requested the office of the city attorney to prepare and present an ordinance. And it's my understanding that the draft ordinance is under review with the city attorney's office now. And once that review is completed, it'll be transmitted to the city council and mayor for further consideration. And I hope that'll happen either later this month or early next month.
Thank you, Jason. The next person, who goes by R, asks, roughly how long does it take DCR to complete land use review for a social equity type 10 application?
Generally, the land use review, regardless if it's social equity or general, takes about 30 business days, but it could take less than that. As part of the lead up to the state's March 31st application deadline, we were expediting the review of the pre-application review records before the department, and we were generally getting them done in less than 14 days, and in some cases less than 7 days. So I would say less than 30 days, and it could be significantly quicker than that, just depending on whether or not we're trying to help people meet a state deadline.
The next question from Tiffany W. Why would the existing medical marijuana dispensary application fees be higher than for other license types?
So the EMMD fees only applied to a brief filing period at the beginning of 2018. And in order to establish that a business did qualify as an EMMD, there were certain documents and records that they had to submit, which aren't required from any other applicant. So, it reflects what the application process was at that time, as well as the different types of forms and documents that need to be submitted to establish that a business was an EMMD. But those fees are no longer being charged, and they haven't been charged unless somebody filed again at the beginning of 2018 when phase 1 was open.
Jason, I think we have time for one more. Roberta asks, I recently logged into my account and I didn't show any applications, but I applied in 2019. How do I find my original application?
You could reach out to DCR licensing at lecity.org, and you can provide us with your ACA reference ID number, and then any information related to that business entity or its location. What may happen is you may have not been linked to the record when it was created because they may not have used your ACA reference ID number. You want to get one or two more out of the way, and then we'll break for the next module?
Okay, I'm fine with that. The next question from Garrick N. What is my deadline to complete this whole process as a social equity approved applicant?
I'm not sure what the question totally entails. There's different processing deadlines tied to the different records. So for the legal business entity record, it's an open-ended record to verify the entity. So there's really no processing deadlines associated with that, but that review needs to be complete in order for you to be issued a license, whether it's for temporary approval or an annual license. For the pre-application review, generally that process is completed within 30 days at the moment. We've been significantly reducing our vacancies in the current year, and we should fall below 20% vacancy rate sometime later this month. And if your pre-app record is deemed eligible for further processing, you have up to a year to submit your temporary approval application. And then I would just invite you to stick around for some of the upcoming modules where we'll get more in depth with the different record types and the different processing times associated with those records.
We have a question. It says, if I won the lottery in December for retail storefront and am interested in applying, the deadlines I need to be aware of are DCC's June 30th and DCR's January 1st, 2025, correct? And would this be for annual
So
license?
for the most important one is for folks that were selected as part of the Phase 3 Retail Round 2 lottery, they have a year to complete the pre-application review process. So you will have to establish your legal business entity record if you're going to pursue the opportunity as a business entity, or you'll have to go through the pre-application review process as a sole proprietor prior to the 1-year anniversary in December of 2023. If you have not already submitted an application to the Department of Cannabis Control for a provisional license, then most likely you're just going to have to pursue an annual license. DCR will begin accepting annual licenses on May 1st, 2023, and that will be an expedited review to help you get to the first level decision maker at the local level, so we can adopt the corresponding environmental docs, which is a requirement for your state annual application. But just in terms of the different dates and stuff, the most important one is there is a 1-year limit on your ability to submit the pre-application review record. And if you haven't completed that process by the 1-year anniversary of the lottery, you will lose the opportunity to apply for that activity. So with that, we're just going to take a few-minute break, and then we're going to let folks get on for the next module. So we'll begin module 2 momentarily. So please hold tight. So good afternoon for the folks that are just joining us. We're going to go ahead and get started in a minute. And for the folks that have been with us since the beginning, thank you for sticking around. Good afternoon. This is Assistant Executive Director Jason Killeen, and we're going to begin part 2 of our Licensing 101 course. So again, welcome to folks who may now be joining us for part 2. And, as part of part 2, we're going to hop into the pre-application review process. We'll also be covering the location compliance and sensitive uses, the pre-application review workflow and the different forms, ineligible locations, different sensitive use restrictions, and some general zoning restrictions. We'll just be doing a brief overview of the fees associated with the pre-app review, and then some resources available to social equity applicants. and then a few of the deadlines that are pertinent to the pre-application review process. So again, we are recording this session, and the recording will be available on DCR's website sometime next week. We will have the different parts of the presentation bookmarked. So if you have to drop or you miss something, you can always come back and listen to the recording at a later date. So thank you all for joining tonight. So what is pre-application review? The pre-application review process was created based on feedback from applicants. Applicants were concerned that they had to submit an application and have executed leases and other things necessary to submit the application before they even knew if their location was eligible for licensure. So what the department did was we worked with policymakers to pull the vetting of the proposed business location out of the temporary approval application process, and we established a standalone pre-application review process. So as part of that pre-application review process, what we do is we look to determine whether or not a proposed location or parcel complies with LAMC 105 and the different eligibility requirements. And you do not need to have site control in order to go through that review. And the goal there was to give applicants peace of mind that they can move forward at a proposed location before they actually submitted the application. And that's kind of important because a lot of the applicants that are coming in now are social equity applicants, and they don't have the ability to hold a location for months at a time while they go through this process. So right now, if you're looking to apply for retail storefront, non-storefront delivery, non-volatile manufacturing, distribution, any of the cultivation processor, the nursery type testing labs, before you can submit your application, you'll have to go through the pre-application review process. And that's where we'll determine whether or not the proposed business premises location is eligible under LAMC section 104.3A3, and does it comply with LAMC section 105? LAMC section 105 deals with the distancing requirements and sensitive uses that DCR has to look at before we can issue a license. So again, as part of the submission for the forms and docs, we only require the landowner attestation for location eligibility, and that's the landowner attesting that the business premises was not subject to any of the reasons that could disqualify the business premises from DCR issuing a license for those business premises. And really, that's information that the landowner would know, not necessarily the applicant. So we do require for the landowner attestation to be filled out, because that's really the applicant's peace of mind that there wasn't unlicensed commercial cannabis activity or some other activity that was cited at the location prior to you executing the lease and trying to move forward in this process. We do have resources available on our website. We have the review workflow, which we'll go over, and then we also have an information and procedure bulletin associated with this process. In terms of the workflow, when the pre-application review record gets created, we issue an invoice for the pre-application review. Again, if you're a phase 3 retail round 2 applicant, we do have grant funds to waive that fee, so you're not required to pay the invoice. And for other social equity applicants, we were deferring that fee in advance of the state's March 31st deadline so that DCR could immediately begin its review of the record to assist you in getting a notice of local compliance underway in the environmental letter that the state required for their provisional license process. Generally, once the invoice has been issued for the $597, you have 30 days allowed by code to pay the fee. Your record status goes to waiting for payment. And then once you've paid the fee, we will workflow your record to pre-application filed, and then we'll begin the land use review. As part of that review, we look to determine whether or not the location is compliant and eligible. In terms of compliance, we're looking at compliance with LAMC section 105, and then we rely on the landowner attestation to determine eligibility. If you're ineligible, you'll get a notification through the system that basically shows that your record is ineligible for further processing. If you have questions about the ineligibility, you can always reach out to your licensing analyst or DCR licensing at lacity.org. If the record is eligible for further processing, it gets workflowed eligible for further processing, which then enables you to submit your temporary approval application. And you do have up to 1 year to submit your temporary approval application. So if, you don't have to have an executed lease or anything else to go through this process, but you do have to have an executed lease to submit your application. So this gives you time to negotiate with the landlord, complete any other business-related decision-making that has to happen before you submit your application, because the goal is once you submit the application, it can be quickly processed to reduce your holding times. So this is just a larger screen print of our workflow. And again, this is available on DCR's website, so I'll just leave it up for a few seconds. But if you want to see the workflow and the IPB, I do recommend you go to DCR's website to see this. An IPB, or Information and Procedure Bulletin, kind of outlines what the process looks like. And it's a quick walkthrough of what we do as part of the different processes. So what I would encourage you to just go ahead and read this Information and Procedures Bulletin at your leisure so that you can better understand the process and what the next steps would be once you complete the process. In terms of looking at sensitive uses, we rely on publicly available data, and that data may be maintained by a state or a local agency. We pull the data on a quarterly basis, and that data is used for the entire quarter. A sensitive use that pops up after you submit your pre-application review record will not be included in the land use review. Once we have determined that your location is eligible for further processing, it does protect your pre-application review record and any application you submit within the 1 year period from future sensitive uses for up to 1 year. It is important to note that sensitive uses include libraries, parks, licensed daycare facilities that are not on a residentially zoned parcel, drug and alcohol treatment facilities that provide on-site non-medical residential rooms. We have permanent supportive housing with on-site services. And that's just a few of, and of course, schools. And those are the primary sensitive uses. If a location is identified on the DCR licensing map, it may not rise to the level of being a sensitive use. We pull the data from the different government websites, and then we provide it to the Department of City Planning to map it. So our DCR licensing map on our website is really a tool to help you as a prospective applicant identify potential sensitive uses that may preclude DCR from deeming your pre-application review record eligible for further processing. Libraries, parks, that's maintained by City of LA agencies, and you don't really see a ton of new libraries and parks coming online. So that information is relatively static. In terms of daycares, drug and alcohol treatment facilities, schools, permanent supportive housing, those things change, and they may change quarterly, they may change monthly, they may change day to day. So the reason why we pull the data on a quarterly basis is it's too hard to review information that changes day to day, and it doesn't give applicants, especially the social equity applicants, the peace of mind to get into the process, because it's an ever-changing landscape, and you don't want to pay fees and make business decisions on a parcel that a day or two from now may no longer be eligible. So what we worked with the city council to change the point at which we make the land use determination from the time we're ready to issue the license to this pre-application review process to give folks peace of mind. And of course, we remove the requirement for folks to have site control in order to allow them to go through this process without actually having an executed lease or site control of the property, so that one, it reduces holding costs, and two, in the event that it's not eligible for further processing, that you won't be out of pocket anything more than the $597 pre-application review fee. So for the four major land use considerations, we deal with the eligibility requirements under 10403, and that's dealt with through the landowner attestation. We look at the distancing of the proposed business location for sensitive uses under LMC section 105. If applicable, for the retail storefronts with on-site sales, we have to look at the distancing from other commercial cannabis businesses that also have on-site sales. It's either a licensed location, a location that's paid their temporary approval application fee, or a location that has paid their business premises relocation fee. That's when those entities plant their flags. Now, commercial cannabis businesses with on-site retail sales are not considered a sensitive use. So when we do our land use review and we deem something eligible for further processing, it is not guaranteeing you that another commercial cannabis business can't move in, because those businesses can continue to move around until you as an applicant have planted your flag. And applicants plant their flags when they pay their temporary approval application fees. So you need to be mindful of that. And then the other piece is the zoning requirements under LAMC 105. So business premises are ineligible if they're owned or managed by a person who holds office or agency in the state of California or any of its subdivisions. The business premises was the site of illegal volatile cannabis manufacturing under Health and Safety Code 11379.6. It was the site of distribution of cannabis to minors. It was the site of illegal commercial cannabis activity after April 1st of 2018. It was the site of a disconnection of utilities under LAMC section 10415E. It was the site of padlocking under 10415.1. So generally, applicants won't know whether or not the owner of the parcel, of course, is a government employee, they're engaged in commercial cannabis regulation, whether or not the property was subject to convictions for any of the things that would disqualify it. Therefore, the landowner attestation is really the applicant's peace of mind that the landowner is attesting that that location wasn't subject to any things that would disqualify DCR from an issuing a license to the applicant at the location. So it's really for the applicant's benefit to get that landowner attestation filled out and taken care of. When we start getting into the distancing requirements for businesses with the retail storefront on-site sales, they have to be outside of a 700-foot radius of a school, public park, public library, alcoholism or drug abuse recovery or treatment facility, daycare facility, permanent supportive housing, and any other licensed retail storefront with on-site sales. For the non-storefront retailer activities, whether it's delivery, distribution, cultivation, non-volatile manufacturing, testing labs, you just have to be outside of a 600-foot radius of a school. And then we haven't accepted any volatile manufacturing applications, but if a volatile manufacturing application, when they get submitted, they'll have to be outside of a 600-foot radius of a school and a 200-foot radius of any residentially zoned parcel. I'm going to just briefly go through this. Basically, the retailer and microbusiness activities with on-site sales have to be outside of 700 feet from one another, as well as the sensitive uses. And the distancing generally is a straight line without regard to intervening structures from the closest exterior wall of the commercial cannabis business to either the parcel line or closest exterior wall of the sensitive use. And it comes down to whether or not the sensitive use has full site control or they have partial site control of the parcel where the activity is occurring. commercial cannabis activities can only occur in certain zones within the city. This information is available on our website, and I'll just briefly go through some of the zoning. For the retailer with on-site sales, generally it's allowed in commercial zones and manufacturing zones, not including restricted manufacturing zones, which are MR. For the micro business with on-site, they are only allowed in the manufacturing zones. For the micro business delivery, which does not allow on-site, so no on-site sales, they can locate in the M1, M2, M3, as well as the MR zones. Anything with on-site sales is not allowed in the MR zones. So make sure when you're looking for proposed business locations, you're not looking at MR zones if you're planning to apply for the retail storefront activity, because that's going to be an automatic ineligibility if it's located in an MR zone. There are no variances, there are no other processes available to allow for DCR to issue it in an MR zone under current law. Only EMMDs had limited grandfathering to continue to operate in an MR zone, and that limited grandfathering is set to sunset in the next couple of years. So all new applicants will not be allowed and have not been allowed to locate in the MR zones for retail storefront with on-site sales. For cultivation, you're looking at the MR and M zones. Same thing for manufacturing. For testing, they can be in a commercial manufacturing zone, an M zone, or an MR zone. For distribution, they can be in the M and MR zones. It's kind of important just to understand what the general zoning restrictions are, and that's one of the reasons why we limit what types of activities can be applied for on the same record, is to really allow for the land use review to focus on things that are compatible. If you apply for multiple activities and one of the activities is not compatible with the zoning or the distancing requirements, the entire pre-application review record is deemed ineligible. And if you want to make modifications to the activities, or you want to change what your proposal is for what activities and where they're going to occur on the parcel, you'll have to submit a new pre-application review record. So we look at the eligibility criteria based on the landowner attestations, and then DCR staff actually do the measurements and do the review of the zoning and distancing requirements within our system. So all of the pre-application review records are submitted online via the DCR licensing portal. Before submitting the pre-application review record, you are going to have to make sure that you have a legal business entity record. If you are planning to pursue as a legal business entity, otherwise you can apply as a sole proprietor. And if you're a verified social equity applicant, then you can apply for the activity types that are limited to social equity individual applicants. Once the record is created, as I mentioned, the $597 fee is applied to the record, and an invoice is generated. If you are eligible for a fee waiver or a fee deferral, please don't pay the invoice immediately. For the fee deferrals, you will have to pay the invoice and outstanding fees at some point in time. So it's up to you whether or not you paid immediately within the first 30 days or you request a fee deferral. And for the folks that have the fee waivers, such as the Phase 3 Retail Round 2 applicants, once staff identify the pre-application review record is associated with the Phase 3 Retail Round 2 applicant, they'll go ahead and waive the fee. So don't worry about paying the invoice. If you have questions about whether or not you're eligible for a fee deferral or a fee waiver, please reach out to the department before you pay the invoice. If the proposed business premises is compliant and eligible, we workflow it to a status of eligible for processing, which then allows the applicant to submit an application. Right now, we're allowing folks to submit temporary approval applications. Beginning on May 1st, we'll be allowing folks to submit annual applications. And the requirements and documents for both are going to be a little bit different, and we'll cover that in Module 2 and Module 4. Once the pre-application review record has a status of eligible for processing, you have up to 1 year to submit an application, whether it's a temporary approval application or a annual application once that process opens. So before I hop into public convenience or necessity, I'm going to go ahead and show you some of the mapping tools in the zoning information map access system, as well as the DCR licensing map. So bear with me as I transition over. So I'm on the DCR licensing map page, which is part of DCR's webpage. This page is available under the licensing tab. So if you go over to the little sandwich menu, you go to licensing and go licensing information, licensing map, you'll be able to get to this page. On this page, we have an embedded map. My preference is to view the map in a new window, which I'll toggle over to in just a second. But the map has different information available to you. So in the find an address, you can type in an address and it'll move the map there. And then over here under our layer list, we have different options and different information, such as pending applications, modification request, locations with temporary approval, social equity businesses. And then we've got the data that we pull from the different government agencies related to childcare, treatment facilities, schools, et cetera. So I'm going to pop over to the full screen map. As you can see, I've already dropped City Hall and City Hall East into the map, so I'm here. So what I'm going to go ahead and do is I'm going to toggle on the different options that we use as part of our land use review. And then just go ahead and close this out. So you can see that there's a park. There's a park right over here. There's also a daycare facility, Joy Picus, right here. So if we were doing a land use review right off the bat, we would say there's potentially sensitive uses there. And then we would go to our list of sensitive uses to see whether or not it meets the requirement for it to rise to the level of a sensitive use. So, you know, the City Hall Park is actually a recreation and park facility, which is right over here. So we know that that would be a disqualifier. Joy Picus is also on the list of licensed daycare facilities. So what we would do is we have the address here. 111 East First Street. I'm going to go ahead and toggle over to ZMIS, and then I'll show you what we do in ZMIS. So bear with me. So now I'm in ZMIS, which is the Zoning Information Map Access System. And this is the City Hall East and City Hall South complex, and Joy Picus is right here in the City Hall South complex. This parcel itself is a public facilities parcel. So it is not residentially zoned, which means that given the fact that Joy Picus has a state license and it's not located on a residentially zoned parcel, it is considered a sensitive use. And then that would further disqualify a retail storefront business from locating at this location. Just toggling back to our map here. However, if we zoom out a little bit, what we see is there's a homeschool or something associated with this, which you can see here is not a legitimate address here. So that would not be considered a sensitive use. And if we zoom out a little bit more, you don't see a school within 700 feet. So although there's a park and there's a daycare facility that would disqualify that parcel for retail storefront with on-site sales, We could issue a license for non-storefront delivery, testing, non-volatile manufacturing, cultivation at that location. So that's some of the stuff you're going to want to look for. The next thing, of course, is when you get into ZMIS, whether or not the parcel is properly zoned. And because it's zone PF, which is not one of the zones we can issue licenses on, we wouldn't be able to issue any commercial cannabis license, which is why generally we do the zoning review first, because if the zoning is off, even if it's properly distanced, we can't move it forward. And if I zoom out, ZMIS has a few different mapping options. One of the nice tools is under the different headers on the left-hand side of the page, you can get information about a parcel. So you can see the different legal addresses associated with the parcel. You have the ability to look at the APN number, which is something that you may need for your state application. You have the ability to look to which community plan area it's located in, neighborhood council, the council district. You have the ability to view different building permit information. You can click on the tab, you can see what types of permits have been pulled, certificates of occupancy, other things for the parcel. You have the ability to look at the zoning. You can see here it's PF for public facilities. You can see whether or not it's a C zone or an M zone. You have the ability to identify if it's in a community overlay area. And then later on, you have the ability to look at public safety related stuff in terms of which bureau or division the local police station and fire stations are in. That will come in handy as part of the PCN process, which we'll jump into next. Some of the other helpful things are within ZMIS, if we do have to do some type of mapping tool, we can look at the radius option here, which is a circle. And depending on if it's retail storefront, we can do a buffer of 700 feet and it'll draw the blue line and it'll highlight any of the parcels that fall within that 700-foot radius. You do have to remember it's mapping from the parcel line to create that radius versus when we're doing our mapping, we're looking at the closest exterior wall. So this is just an initial tool to identify if any of those sensitive uses are triggered before we get into the more exact mapping tools and the distancing, which is over here. For anything other than retail with on-site, the buffer is going to be 600 feet. So that's the general buffer we've been using a lot. And you can do a couple of things with this. They have options to change the background displays. So if we do have to get into mapping, I would typically toggle on the digital color aerial maps so that we can see where the footprints are for the different business and any of the other structures that are on the parcel. And then this, of course, comes into handy if we're doing any types of measurements. So hypothetically, you know, if we were applying for any type of commercial cannabis activity and the activity was in this corner of the building, that would be the exterior walls that we would be measuring from. This little button over here, the measuring tool, you can actually click on a piece of the parcel anywhere in the map, and then you can drag it over to where you think the sensitive use is or where it's identified on the map. And then when you double click on the endpoint, it will actually show you the distance in feet based on these mapping tools. So this is a tool that DCR staff use on a daily basis to do these land use reviews, in addition to the licensing map and the publicly available information on the DCR website. There's no tricks, there's nothing hidden. The mapping tools that are available to prospective applicants, their consultants, and their law firms are the same sets of tools DCR staff use on a daily basis to make these land use determinations. So the information we're using is information that you can access and use yourself prior to submitting these pre-application review records. So those are just some of the tools. Again, within our map for any of the sensitive uses that pop up, you should get information about what the name of it is, the type of sensitive use it may be, and a particular address for that. And this, of course, is information that DCR staff uses to review against the state list that we pull and to look to see whether or not it rises to the level of meeting the definition of a sensitive use. So again, just because you see something here on the map, like we identified with the school that's not actually here, this is intended to allow you to do your own due diligence. And then, of course, even if something's there, we do review that information to see if it does rise to the level of being a sensitive use before we make our land use decisions. So we'll probably get some maps or some questions related to that a little bit later. I'm going to go ahead and pause my screen and transition back to our presentation. So just bear with me one sec. So one of the changes that was made previously was moving the public convenience and necessity process to after the pre-application review process. When the city had its public convenience or necessity pilot program, the code was written in a way that did not allow DCR to process any aspect of the application before the PCN request got submitted to the city council. So somebody could go through the full-blown the PCN process, have the council make a finding of public convenience or necessity, and then DCR had the authority to begin processing that application. And for at least one of the records where council made the finding of public convenience or necessity, when DCR began the review for land use purposes, we determined that the location was too close to a sensitive use, and we were unable to move the application forward in the process. So you can imagine that that prospective applicant was very unhappy that they went through the time and effort of getting a PCN request only to be told later on that their location was too close to a sensitive use and they couldn't submit an application or pursue licensure at the location. So we worked with the city council to amend the policy to allow DCR to do the review of the pre-application review record. And then if we make a determination that it is subject to a finding of undue concentration, then to allow the applicant to enter into the public convenience or necessity process. So now I'm just going to take a couple of minutes to run through what that process will look like now. So any applicant seeking to engage in retail storefront with on-site sales, cultivation, and volatile manufacturing in a community plan area that's unduly concentrated, which we refer to as a finding of undue concentration, would have to file a request with the city council and get a public convenience or necessity finding prior to DCR accepting the application. I just do want to note that the PCN process is not available at this time, and hopefully it will open up and be available later this year. We do have an information procedure bulletin about the public convenience or necessity process. It was last updated in October of 2020. It reflected the process that was in place for the pilot program. It will be updated to reflect the new process and how we start making these determinations prior to us reopening the public convenience or necessity process. And we'll be working with the Planning and Land Use Management Committee and other stakeholders and policymakers over the next few months to get their input about the process and then hopefully open it up. Generally, as part of the PCN process, once we've This is the actual original workflow. What'll happen now is folks will go through the pre-application review process, and if we find that it's subject to a finding of undue concentration, the prospective applicant could engage with stakeholders, fill out the necessary stakeholder outreach forms, complete the PCN request form, and then upload it via the DCR licensing portal. You would be invoiced for the PCN filing fee, and then once the fee gets paid, DCR would review the information for completeness, and then we would transmit the PCN request to the office of the city clerk, and they would assign a council file number. And then the city council has 90 days to make the necessary public convenience or necessity finding. If the city council does not make the finding within 90 days, the PCN request is denied by operation of law, and it results in us closing out the PCN record. If within the 90 days, council makes the PCN finding, then DCR has the ability to allow the pre-application record to move forward, and then you would be able to submit an application. So really the only difference in this process is the pre-application review is going to come first. You'll have peace of mind that it's properly distanced from sensitive uses. Remember, other commercial cannabis businesses with on-site sales are not considered a sensitive use. So, you will have to make sure that you don't have any competitors within 700 feet prior to submitting your application. But once you get through this process, if you get the finding, you'll have the ability to submit the application, whether it's a temporary approval application or an annual application. The PCN request form is available on DCR's website, as well as the stakeholder input request forms. The PCN finding, this is fairly easy to populate if you use ZMIS. You can enter the business premises address, you can identify the community plan area, the council district. I would hope you know the applicant name and the contact information for the applicant. You can enter your proposed operating hours. You can enter information related to a business improvement district if it's within one, the local neighborhood council, et cetera. You'll be able to get all of that information from ZMIS. And that's kind of what I was talking with folks about a little bit earlier is when you get into ZMIS, the headers that we have tagged are ones where you would be able to glean the information necessary to complete a lot of what's on that public convenience or necessity filing form. In terms of the stakeholder input, there's different stakeholders that you're required to reach out to. So you could indicate which type of stakeholder you're reaching out to. You can put the name of the stakeholder. Some of that information you can glean from the ZMIS information, such as the substance abuse intervention, prevention, and treatment facilities. If you go to the DCR licensing map, we do have the licensed locations that have the non-medical residential services associated with them, but there may be other ones that are substance abuse intervention, prevention, treatment organizations or facilities that are not there, and you can do your due diligence and reach out to them. It doesn't have to be one of the sensitive uses identified on our map. And then of course, you'll put your council file number. That will be issued to you once you've submitted the form and we filed it with the city clerk. They'll assign a council file number. We will upload that to DCR's website and communicate that to you. So if any of those organizations or stakeholders have public comment that they would like to provide to the city council, they could go ahead and file it under that council file number. The cost for filing a PCN request is $1,592. There may be a written notice fee of $484 if we are required to provide notice on your behalf. And then of course, we prepare and issue an invoice for the PCN filing fee and any applicable notice fees within 10 days of the PCN record getting created. Again, only certain applicants are eligible to go through the PCN process. Therefore, we have to do the review of the record before we issue an invoice because we don't want people paying invoices for services that we're not going to be able to render. Jumping into the social equity program, the program is intended to promote equitable ownership and employment opportunities. There are a number of services that Dr. Amani Brown and her team are providing. business licensing and compliance assistance. Every verified social equity individual applicant has access to the learning management system. Folks can reach out to the social equity team to find out about pro bono, low bono legal assistance services, one-on-one coaching. We have a job board. We have different workforce development tools. And of course, from time to time, we get state grant monies to provide direct financial assistance to businesses. Our last seed grant program closed on March 31st, and I know Dr. Brown and her team are working on securing additional state funds so that they could do a seed 3.0 to provide further financial assistance to our commercial cannabis businesses. So if you have questions about what programs and services may be available to you and you're a verified social equity individual applicant, please reach out to our social equity team. Upcoming state deadlines that folks need to be aware of. June 30th is the date that DCC has to issue provisional licenses. So if you apply with the state and you're not issued a provisional license by June 30th, you will be routed to the state's annual application process. DCR is going to be transitioning away from temporary approval. So there's going to be a last day for general applicants to file new temporary approval applications, which is June 30th, 2023. And the last day for social equity individual applicants to file a new TA application is July 31st, 2023. There's a 1 month difference there just because the state is processing new provisional license requests and the state has until June 30th to issue them. And there may be folks that completed our pre-application review process, got their letter of local compliance underway and their environmental document, and they wanted to see if the state would issue a provisional license before they submitted the temporary approval application. So folks have the ability to get peace of mind about whether or not they can get their provisional license before they submit their temporary approval application with DCR. And then of course, we've given them the additional month to get that application in if they are successful in getting the provisional license. So for folks that are not able to get a provisional or temporary approval license, they will have the ability to get an annual license, and our director has really streamlined the annual application process and switched things around to make the process more efficient and then allow applicants to get peace of mind about whether or not they will be issued an annual license before they have to meet all of the other local permitting and business requirements that can come after that process. So we'll talk about that a little bit later in the presentation. Again, we just have some links to the state resources for their licensing process. I do encourage you to reach out directly to the state if you have questions about their process because they're best positioned to ask those questions. And we were going to go ahead and take a 5-minute break. I'm going to just ask staff to take a 3-minute break. I'm going to grab some water and then we'll jump into questions. And, we'll answer as many questions as possible. And what we're doing is any of the questions that get asked and we're unable to answer during the module, we're going to hold to the end of the presentation with the hope of trying to get to them at the end of tonight's presentation. So we will be back at 4:48. I'm going to go ahead and mute myself. So please stay tuned. Hey, Gidget, I'm ready to hop into questions if you are.
I am ready. Let me start with the first one from Tiffany W. My question is, at what specific point in the application process is an applicant's 700-foot flag planted?
So the flag is planted the earlier of when a license is issued, when a temporary approval application is submitted and paid for, or when the business premises relocation fee is paid for. So under the original code, a flag was not planted until a license was issued. So, up until the point where DCR was ready to issue temporary approval, you had no land use protections. So that is the original legacy language. Director Garakian and previously Director Packer both worked with the city council to move the needle for when a flag could be planted. And the temporary approval application process and the payment of those fees is one of the earlier ways an applicant can plant their flag. And then for existing licensees that are seeking to relocate, once we've done the land use review to determine that their modification and relocation is eligible for further processing, if they pay the business premises relocation fee, they would be eligible to plant their flag.
Our second question comes from David W. What happens if the lease owner changes their mind on the lease space after you submit it?
So if you're unable to execute a lease with the landlord, or the landlord chooses not to work with you, you have the ability to, if you have an application submitted, you have the ability to submit the business premises surrender form, and then we can abandon your application. And then you have the ability to then refile for the activities listed at another location. If you're in the pre-application review process and you haven't submitted an application, you can withdraw your pre-application, you could cancel it, or it will just naturally time out after 1 year if you don't submit an application.
Our next question is also from David W. How do you submit for a change of lease location, which I think you just went over?
So pre-application review records cannot be modified. We do the land use review based on the location. So if you're unable to move forward at that location, you'll have to find a different compliant location and go through the pre-application review process anew. If you submit an application, your application is not complete unless you have an executed lease or some other form of site control. So if you submit the application, that application may be abandoned if you're unable to gain site control and have an executed lease. Of course, if you have a license, then you have something tangible. And what's happened for folks in the past is they submit their renewal for their license, and then they don't pay their fee, and then their renewal application gets deemed abandoned, and then they have the opportunity to refile. If you do have an active license and you're able to find a new compliant location, basically we can put a hold on your license. So it's not being used, it's not in operation, while you go through the relocation process and then seek licensure at the new location. So there's a bunch of different options depending on where you are in our process.
Thanks, Jason. Moving on, question: Bay City fees that they need to pay from start to finish for a new distributor permit.
You would, if you're, for the land use review, it's $597. If you have to go through the equity share review, that's $1,248. The combined fee for the legal business entity record and the temporary approval application, if you're eligible, is $5,720. There's also a Los Angeles Fire Department inspection fee that goes along with the temporary approval application, and I think that's $1,336. Generally, those are the fees that have to be paid to get to temporary approval. Of course, for the annual application process, where you have to have a certificate of occupancy that matches the activities, you have to get your public health permit, you may have to go and pay additional fire permit fees. There could be additional fees that you would have to pay if you are going to pursue an annual license. But I would recommend reaching out to the Department of Building and Safety for your location and which activities you plan to apply for or pursue, in order to determine whether or not the parcel has the right C of O and other permits for you to pursue that activity, or if you're going to have to make amendments to those documents in order to pursue it, because that will significantly increase the cost.
Okay, our next question comes from Lonel C. I already submitted all of my pre-app documents. It has been 2 weeks. What is the timeline for a response and what's next for me to do?
Yeah, so the pre-application review records are reviewed and moved within 30 days. So we were expediting the review of social equity applicant records that were submitted prior to the March 31st date, to help those applicants get their letters of compliance underway. So if it's been in there for 2 weeks, it'll probably be reviewed either sometime next week or sometime the following week, but definitely within 30 days. And then, of course, if your pre-application review record is deemed eligible for further processing, then you'll have the ability to submit your either temporary approval application or, beginning on Monday, May 1st, your annual application.
Hey, Jason, we're going to try for a couple more and looking at the time. We have a question or similar question from 2 individuals, Sue Y and Nick S. When will the lottery be drawn again?
I don't have an exact date, but the director is pushing to hold the next lottery sometime later this year.
And then the next question from Kevin B. How do I apply again? I'm trying to get through the application process.
So all of the application related materials are available on DCR's website, and they would be submitted through the DCR licensing portal. And links will be available as part of this presentation, and they're also available on DCR's website.
Can you do one more, or should we stop for a break?
If there's 1 or 2 quick ones, I can get through them.
Okay. What type of, this comes from E&E, I apologize. What type of licensing do I need to manufacture, cook and infuse, and only sell wholesale?
So for the manufacturing component, you could do the type N, which is for infusion, or you could do a type 6, which allows you to engage in all non-volatile manufacturing. And for the selling wholesale, depending on whether or not you're going to transport the cannabis products to the testing lab and or to other businesses, you may need to have a distribution license. So at a minimum, you're going to need either a type N or a type 6 to manufacture commercial cannabis products. And you may need a distribution license depending on how you plan to move those products to other licensed businesses. Do we have one more, or should we get ready for the next module?
We do have one more. It should be quick. Javier B. Is undue concentration map in real time?
No. So the undue concentration map, the sensitive uses are updated on a quarterly basis based on the data available on the first day of the quarter. So the next refresh of the map will be on Monday, May 1st. We'll pull the information from the different state and local agencies. And then it takes city planning about a week or 2 to get that data refreshed. And then the sensitive use data will be valid through the next quarter when we pull the new data. For the retail storefront and the different application maps, we try to update those every 30 days. And we're working with city planning and our system programmer, Excella, to integrate the ArcGIS Online account with our DCR licensing portal to try to get the application and retail storefront information updated on a more timely basis. So stay tuned for that. And thanks, Gidget. I'm going to go ahead and progress it. We will be beginning the next module in a few minutes. So I'm going to go ahead and pause sharing and mute, and we'll see you again right after the 5 o'clock hour. Good evening and welcome to part 3 of our Licensing 101 session. Welcome new folks that are just joining us. My name is Jason Killeen, Assistant Executive Director. And for the folks that have been with us for the last hour or two, thank you for sticking around. So as over the next 2 modules, we're going to be going through the difference between the temporary approval and annual licensing processes. This module is going to focus on the temporary approval process. So as part of our agenda, we're going to be going through the temporary approval licensing process, the procedures bulletin and workflow, the documents needed for a temporary approval application, the fees, various SEP resources available to social equity individual applicants, a few of the state and DCR deadlines that are applicable, and then we'll get into a question and answer session. So in order to submit a temporary approval application, you will have to have completed the pre-application review process, and that record will need to have been deemed eligible for further processing. We're currently accepting applications for non-volatile manufacturing, distribution, and testing labs from all applicants. Social equity individual applicants are also able to submit applications for non-storefront delivery, as well as cultivation processor and nursery license types. And then folks that were selected as part of phase 3 retail round 2 are eligible to go through the pre-application review process and then submit applications for the retail storefront commercial cannabis activity. We are not accepting applications for volatile manufacturing from any applicants. And then, of course, we did get some questions earlier in the presentation about on-site consumption and special events. And at this point, DCR is not accepting applications for those 2 activities either. So 2023 is a big year. the state is going to be phasing out their provisional licensing program and transitioning strictly to an annual application process. So DCR is also going to be transitioning away from temporary approval and into the annual licensing process so that we're in alignment with the state of California. Because of the dual licensing requirement, you do have to have a local license and a state license, as well as meet other permitting requirements in order to operate a commercial cannabis business. So in order to get a state annual license, you will have to have completed the city's annual licensing process and be issued an annual license in order to have a complete state application. So if you do not have a provisional license or you're unable to renew a provisional license, you will not be able to operate until you get that state annual license. So for folks that have not received temporary approval that don't have a state provisional license to utilize, it will be in your best interest to go into the annual application process so that you can meet these new state requirements. I'm going to be able to provide a timeline for the temporary license deadlines later in this section, typically at the end. So temporary approval is a DCR issued temporary license that authorizes an applicant to engage for a limited period of time in a commercial cannabis activity that would be permitted under an annual license or a non-temporary license. In terms of the mechanics for the provisional and temporary licenses, they were always intended to be temporary. They don't deal with CEQA compliance, which is the California Environmental Quality Act. So in order to get a provisional or temporary approval, businesses did not have to have an adopted environmental document, which is a requirement for the annual application process. The state is phasing out provisional licenses, which is going to necessitate the city phasing out its temporary approval process, because in order to qualify for a state annual license, businesses will need to get a local annual license and have DCR and the city council as the local agencies adopt the necessary environmental review documents. DCR has delegated authority from the city council, and the Cannabis Regulation Commission also has delegated authority from the city council for different license types. And then of course, the Cannabis Regulation Commission or city council may be second level arbiters for denials. So those are some of the things that go along with the decision of whether or not to issue an annual license, is when it gets to that first level decision maker and where appeals can be made. But DCR cannot adopt the environmental findings separate and apart from the discretionary action that it's tied to, which is the issuance of the annual license. So our temporary approval workflow is fairly unchanged, other than the fact that when we created the legal business entity record last year, we pulled all of the ownership, primary personnel, equity share, compliance with LAMC 10420 out of the application process, and we put it in its own record type. So once a business had been vetted and the ownership approved, or the equity share requirements have been met for the business, they wouldn't have to undergo that same review every time a new record was submitted, or every time they submitted a relocation request, or they needed to update their ownership. So that was an onerous requirement, and the director was able to use her promulgated authority to create the new record type to allow for us to do that review separate and apart from the application, and that streamlined the application process. So once the application gets submitted, the applicant has 30 days to pay. Certain applicants are eligible for fee waivers, such as phase 3 retail round 2 applicants, and other social equity applicants may be eligible for a fee deferral by request. Once the application has been deemed filed, we begin reviewing the application. Once the application is complete, so all of the necessary document forms are filed, and then of course equity share review, if applicable, is necessary for the record, has been completed, we issue a local compliance underway notice as well as a notice of environmental review to let the state know that we've begun our environmental review of the project. Once we've completed that, if the equity share review hadn't already been completed, it will need to be completed, and the business will have the ability to request an initial inspection. Once those two things are done, we issue temporary approval, and we will begin accepting annual applications from new applicants and existing licensees beginning on Monday, May 1st. In terms of the information and procedures bulletin, we have this online and it's going to be phased out. So we haven't updated it to kind of reflect some of the new policies and some of the new timelines because it's going to be phased out, but it provides a general overview of what the temporary approval process is. And then of course, for the review that's applicable to either the equity share review or the ownership related documents, that's now just being done on the legal business entity record, but those processes remain the same. We just don't have to do it if a business that's already been verified is applying to operate at more than one location. So there's a savings there. And there's also a savings to applicants that want to establish their business and go through the equity share review and then bring on investors prior to submitting an application to reduce the holding costs from the period of time that they actually have to secure the location and when they can navigate through our application process. So in terms of the deadline requirements, once the pre-application review record has been deemed eligible for further processing, the applicant has 1 year to submit their application. Any pre-application review record that has not been utilized within that 1 year just gets closed out by operational law. Or if you lose site control and you submit the business premises surrender form, the record can be closed out or abandoned. A few of the things that folks can use as resources is we got the temporary approval workflow on our website. We've got the information and procedures bulletin. We've got information about the entity eligibility verification for the social equity program. And we have the refiling workflow. So if a temporary approval record was deemed abandoned and it's eligible for refiling, how general applicants and social equity applicants can go ahead and refile. For the required forms, it's a lot more streamlined now that the ownership and primary personnel documents are on the legal business entity record. So now we're looking at pretty much indemnification agreements and attestations and being able to identify the business premises diagrams and verify it for compliance, and then you're eligible for your initial inspection. So this application process and what these requirements are going to be very similar for the annual application, with the caveat that as part of the annual application, we do have to do the environmental review. So the Form 4013 will also be required as part of the annual application. But what we've tried to do is get the longer review taken care of on the legal business entity record. And we've created an internal unit that is focused on reviewing those legal business entity records. And that's all they're doing is doing those records and then doing the equity share reviews for the social equity businesses. And then that's going to allow licensing staff to focus on application processing and scheduling inspections. And what the director is trying to do now is she's trying to create a program that reduces the holding costs for applicants and licensees and gives them the most flexibility in determining when they're going to lock in a location, or they're going to make some of these core business decisions in terms of tenant improvements or pursuing different permits outside of DCR's regulatory bubble, and having a sufficient amount of peace of mind that they can get either a temporary license or an annual license before they have that large capital outlay. In terms of the indemnification agreement, you're indemnifying the city. So we do require notarized signatures there. It is a requirement within the municipal code. We also have the labor peace agreement. California law does require businesses with 10 or more employees to enter into a labor peace agreement. So it's just attesting that you're going to comply with state law. You'll also have to, comply with state law when you submit your state application. We do have the landowner attestation that is acknowledging that you as the lessee or an applicant have the legal right to occupy the business premises location and engage in the commercial cannabis activities that you're applying for. The temporary approval attestation is you're attesting that you understand the requirements and you meet all of the requirements for temporary approval. We also have an attestation for no alcohol or tobacco. Commercial cannabis businesses are not allowed to sell alcohol or tobacco at the site. So this is making sure that the owners of that business understand that they're not allowed to engage in alcoholic beverages or tobacco product sales at the business premises. And then we have the initial inspection attestation. Basically, it's giving you an overview of what DCR personnel will be looking at during the initial inspection, and you're attesting that you're ready for that initial inspection. If DCR personnel find any deficiencies during the initial inspection, you'll have an opportunity to cure those deficiencies, and if applicable, go through another inspection. The premises diagram, the Bureau of Cannabis Control, the Department of Cannabis Control, you can do your own business premises design. What we've seen is a lot of folks are doing more professional business premises designs that are intended to allow them to go through the fire department, the building department, water and power, and others that do require more than a basic drawing. We do accept those, but the bare minimum is a hand-drawn diagram that complies with these minimal requirements. Again, we are intending to reduce barriers to entry. So really, we're focused on only the things that are applicable to DCR and what's important to DCR. So if you do have to submit plans to the Department of Building and Safety, they will require something a little bit more than what this premises diagram is. So it's always a good idea to reach out to the building department, the fire department, and others to see whether or not you're going to have to either pull permits or do any work with them, so that when you start to put together those packages, you can identify what level of effort is going to be necessary to comply with all three. Most city agencies are not going to ding you if you do more than what they ask for, or it's done in a more professional manner. Folks will ding you if you don't meet their minimum requirements. So these are DCR's minimum requirements, and you get a gold star if your plans are professionally done, and they would be accepted by the Department of Building and Safety. You also have to provide an executed lease agreement or some other form of site control. The business formation and organization documents are no longer required. They are on file on the legal business entity records. For the existing licensees, as part of the renewal process, they were required to create the legal business entity records so that those documents could be moved over. And of course, the equity share review documents are now in the legal business entity record too. For the formation and organization documents that we used to review as part of the temporary approval process, these have all gotten moved over to the legal business entity record. Folks are going to have a legal business entity record in order to submit their annual application. But for temporary approval applicants that don't have temporary approval, we are still reviewing those documents as part of your temporary approval application. But when you do get ready to move over for your annual application, you will have to make sure that they're uploaded to your legal business entity record. If we've already vetted these documents as part of your temporary approval application, and there's no changes between the documents that we've already reviewed and approved as part of your temporary approval application and the documents you upload to our legal business entity record. There are no additional fees for creating the legal business entity record. And then, of course, we'll mark those documents as approved on the legal business entity record, which will expedite the processing of your annual application. If there are changes that need to be disclosed to the department and they're disclosed through the legal business entity record, you may be subject to modification fees. And then once we complete the vetting of your legal business entity record, of course, then we would be able to start working on and complete the review of your annual application. Same thing for the equity share documents. For new applicants, this review is being done on the legal business entity record. For existing phase 2, phase 3 retail round 1 applicants, this can be done as part of the temporary approval application process. If you do receive temporary approval and you go to submit your annual application, provided the documents haven't changed, we can go ahead and vet them on your legal business entity record, which will expedite the review of your annual application. If you don't reach temporary approval or your temporary approval record is abandoned, in order to refile, you will have to upload the documents to the legal business entity record and they will have to be vetted. So we're trying to reorganize and structure things with minimal impact on applicants and licensees. And to the extent that the information has already been reviewed and approved by the department, we're not going to be re-reviewing and charging additional fees. But if changes have been made, in lieu of charging you the larger filing fees, we would just charge the lesser modification fees for the changes that are occurring. So that's to help facilitate compliance and then the transition to our annual application process. I already went through fees for the temporary approval process earlier. The annual license application fee is $7,691. The temporary approval application fee for all applicants now is $5,720 because we're assessing the a la carte equity share review fee for businesses that need it on the legal business entity record. So that makes sure that the application fees are consistent. And then, of course, for people who have already paid the $57.20, that covers the documents that are part of the temporary approval application, as well as the documents that are now living on the legal business entity record. So for those folks, we're not charging any additional fees provided the documents are the same between both records. For the social equity program, again, the intent of the social equity program is to promote equitable ownership and employment opportunities, to decrease disparities in life outcomes for marginalized communities, and to address disproportionate impacts on the war on drugs on those communities. Dr. Amani Brown and her team have put together a fairly robust social equity program that has business license and compliance assistance. They've implemented a learning management system, or LMS. Currently, there's over 140 hours of self-paced educational content and webinars on the LMS system. Every social equity individual applicant has access to the LMS. You can also reach out to the social equity team if you don't have access to it or you don't know your password, because they can help you reset it. The city has partnered with the Los Angeles County Bar Association, or LACBA, and they have a smart law referral service. So social equity individual applicants are eligible to receive up to 10 hours of pro bono legal assistance and up to 30 hours of low bono legal assistance for $35 per hour. To sign up for the pro bono or low bono legal assistance programs, please go to the link that's listed here, and then you could submit your information. TCR is also offering free coaching for social equity entrepreneurs. This is a great tool for folks that either haven't gotten into the application process yet, or they've gotten stuck somewhere along the application process. One of the coaches will, schedule you for a 15-minute virtual assessment to try to help identify what tools you need or where you're stuck and provide guidance, and then move you on for additional programming. The social equity team has also put together a job board. So the job board is intended to be a user-friendly platform for employers to promote different job openings and connect with qualified candidates who are interested in working in the cannabis industry. This is intended to, help businesses meet their local hiring requirements. There's also a workforce development component where employers and job seekers can get free coaching, interview training, resume review, resume writing assistance, etc. And for employers, they have training on recruitment and hiring, onboarding, retention, offboarding, and the different types of skill sets that may be needed by license type. And our most recent round of seed grant funding ended on March 31st, but Dr. Brown and her team have been applying for additional state grants. And if any of those grants allow for direct financial assistance, I look forward to them implementing a Seed 3.0 program and then letting folks know how they could apply for that direct financial assistance. So stay tuned for that. Important deadlines, again, the Department of Cannabis Control can continue to issue provisional licenses to local equity applicants through June 30th of 2023. Anybody that doesn't get their provisional license by June 2023 is automatically going to be routed into their annual application process. Of course, in order to meet their annual application requirements, you're going to have to complete the local annual licensing process. For DCR, any application that's abandoned after June 30th of 2023 must be refiled as an annual application unless you have an active state provisional license. June 30th is also the last day for general applicants to file for a new temporary approval application. July 31st is the last day for social equity individual applicants to file for a new temporary approval application. After that, all applications will have to be filed as annual applications. The city has limited non-storefront delivery, the retail storefront, and micro business with on-site sales to social equity applicants through January 1st of 2025. We do intend to hold additional lotteries until we've reached undue concentration for the retail storefront as well as the cultivation activities. We will be making some policy recommendations in the future to see whether or not policymakers are willing to allow for us to make some modifications to ease the land use burden, as well as increase opportunities in the commercial cannabis sector. So stay tuned for that. And then, of course, applicants are not going to have provisional licenses at the state level anymore beginning on January 1st of 2026. So all of our existing licensees need to transition to a local annual license and a state annual license before the business is no longer eligible for provisional licensure at the state level. So December 31st, 2025 is the last day any business will be allowed to operate under a provisional license. But depending on when a business's license expires, they may not be able to renew. The state is not allowing new renewal provisional applications to be submitted beginning on January 1st of 2025. So basically, we have put together a plan to ensure that local licensees have the ability to get their local annual license so that they can meet the state's annual licensing requirements sometime in 2024. And it's really going to be up to the individual business to ensure that they're navigating through the local annual application process as quickly as possible so that you can get into the state queue for your state annual license, because we don't want any business to have to stop operating because they were unable to meet a state deadline. And then, of course, we've kept our temporary approval renewal process open through December 31st, 2027. Folks will be able to renew temporary approval into the 2027 calendar year, and I'll cover that in a little bit more detail when we get into the annual application discussion as part of Module 4. Again, here are the links to the Department of Cannabis Control's resources. And we'll take a 5-minute break. We'll reconvene probably around 5:35, and then we'll jump into the Q&A session. So I'm going to go ahead and pause sharing of the screen, and we'll be back in about 5 minutes. Thanks, everybody. Good evening, everybody. Gidget, if you're ready, we can go ahead and jump into part 3's question and answer session.
Okay, thanks so much. Here we go with our first question from Norman S. Can you operate on metric after receiving temporary approval?
So the metric system, which is the state's track and trace system, is administered by state agencies. So receiving temporary approval from DCR doesn't get you access to metric. You won't be able to do that until you've met the state's licensing requirements.
Ingrid A asked, if I applied to social equity and was verified, but not chosen in the lottery, how do you start the process again?
So if you are a verified social equity individual applicant, you do have the ability to apply for non-storefront delivery, distribution, non-volatile manufacturing, cultivation processor, nursery testing. We will be administering a future lottery. And as a verified applicant under current law, if you were verified to participate in the 2022 process because you got verified in 2022, you would be able to participate in the upcoming lottery. So as we get more information on when the lottery may be administered, we'll put that out there and then we'll notify folks that are eligible to participate via email.
Our next question comes from T. McD. Can we get a list of available properties that could be considered to relocate?
So there's never been a list, and DCR wouldn't be able to put together a list of properties that may comply. So if you have a proposed location, you could go through the land use review for that proposed location. If you're an existing licensee, you can submit a relocation request and we can vet the location for compliance. And, if it's eligible for further processing, you can either choose to pay the business premises modification relocation fee and start to move there, or you could decide to stay at your current location. Unfortunately, we don't have a list of available properties. We don't reach out to landlords or anybody else to see if they would be willing to do business with a commercial cannabis business. But we do have the tools on our website, our licensing map and ZMS, that you could utilize to try to identify compliant locations.
Thanks, Jason. We have a second question from T. McD. How do we update the licensing portal if it has incorrect contact information for owners? Excuse me.
It really depends on what information you're trying to update. If you're trying to update contact information for you as an individual or for the business entity, you can log into your ACA user account and you'll be able to edit some of your contact information. If the legal business entity record doesn't have the correct owners or primary personnel or financial interest holders, you could submit a modification request against the legal business entity record in order to update that information on the record. So it really depends on if you're trying to update your contact information as a user. And then ultimately, once you've done that, it'll sync with the records that your user profile is associated with. Or if you're trying to update like documents that have been submitted as part of a record.
All right, our next question comes from Ian E. What are the parameters/qualifications for manufacturing? Do we need a license if we're only dealing with CBD? All questions pertain to the infusion of food, for example, sugar, chocolates, honey, and salad dressings.
So anybody engaged in commercial cannabis activity need to have a local license as well as a state license, plus meet the other permitting requirements to engage. So CBD is a byproduct of the cannabis plant. So unless the CBD is derived from industrial hemp as defined by state law, if you are dealing with CBD derived from anything other than industrial hemp, you do need a license from both DCR as well as the state agency. And if you're infusing the CBD into any type of food product, at a minimum, you would need a type N license, which is for non-volatile manufacturing, to infuse food products, or depending on what else you're infusing or how you're extracting the CBD out of the cannabis plant material, you may need the full type 6 manufacturing type.
Thanks, Jason. Question from Lewis H. What is the availability for fee waivers, and how is the city assisting applicants?
So DCR earmarked funds for fee waivers for phase 3 retail round 2 applicants to try to help facilitate getting them through the application process using one of our state grants. The director recently got permission to extend the fee deferral program. Previously, fee deferrals, deferred fees were due within 6 months of the deferral being granted or licensure, whichever was later. And a lot of our phase 2 applicants that have had their fees deferred for a number of years were shocked when they finally met the requirements for temporary approval, only to be issued a $30-something thousand invoice to cover all of the deferred fees that needed to be paid before they would get their license. So council recently adopted a recommendation to allow her the discretion to extend the deferral up to 1 year after a license has been issued. The fee waivers themselves are all based on grant monies, and we have to apply for those grants in advance and then earmark them for certain programs. So I would recommend reaching out to the social equity team to let them know what your circumstance is, to identify whether or not you may qualify for a fee waiver or how you could qualify for a fee deferral. And then, of course,
Go ahead. I'm sorry.
No, sorry. For the, how is the city assisting applicants? I mean, there's a lot of different ways. The director has been very cognizant about the feedback she's got to simplify and streamline the process. And on the licensing side, we're doing everything possible to reduce fees, streamline, make things easier, improve processing times. And then, of course, Dr. Brown and the social equity team are busy putting together all types of collateral material and finding vendors and working with the legal team and the LA County Bar Association for the pro bono and low bono services, expanding the learning management system. The director has really put a focus on stakeholder and community outreach. And, as folks have seen, we've been doing a lot of more Q&A sessions and webinars and virtual meetings with folks and stakeholder meetings to get input about our processes and how we can better the processes and make them more efficient. So that's just a small sampling of what DCR is trying to do to assist applicants and licensees be successful. We've recently got a series of almost 20 recommendations through the mayor and city council that will further streamline the annual application process so that we can get people an annual license before they have to actually meet all of the different permitting and operating requirements, because we know that folks now need to get that state annual license as well, and they can't do that until the environmental doc has been approved. So we've kind of shifted the final inspection and the demonstration that the business has met all of the different permitting requirements until after we've issued the annual license and after the business has gotten their state license to kind of reduce that financial burden and give folks peace of mind. So there's a lot of things going on. I don't want to toot our horn too much, but the director has been very cognizant about trying to make the process better.
Thanks, Jason. Looks like we have one more question, and it comes from Christina B. Pertaining to the provisional license. If for some reason my initial approved building cannot meet certain requirements needed in order to pass inspection to obtain licensing, will we be able to switch our building to a different compliant building, or will we just lose our opportunity to get licensed?
So if your current building, for whatever reason, either you've lost site control, you've made a business decision that it's too expensive to do tenant improvements necessary to get the permits from building and safety or fire or public health, if you submit the business premises surrender form, that's a reason DCR may abandon an application. And then if we abandon an application, you have up to 1 year to refile that application. So that would give you a year to find a different compliant building and then pursue licensure at that specific location. And recently, City Council adopted one of DCR's recommendations to allow to extend the refiling period from 1 year to 3 years. So hopefully, City Council will be weighing a draft ordinance to effectuate that change, and hopefully they'll get it adopted so that folks that are in this situation don't have to rush into making other business decisions. They can be a little bit more deliberate and thoughtful, and they'll have more time if they do need to switch to a different location.
Thank you, Jason. I don't see any more questions in the Q&A, and we finished all those pre-submitted.
Oh, wonderful. Let's give folks just a minute or two to try to submit any other questions, and then we'll close the questions for this module at 5:50. And if we still don't have any more, we'll just recess early.
Jason, I think another few questions have come in. Are you available?
I sure am.
Okay. Excuse me. In the event that two retail P3 applicants are within 700 feet, is the one eligible the one whose invoice is issued earlier?
It's not, so we'll have to be a little bit more specific when we talk about the applicants. So for phase 3 retail round 1 applicants, it's the payment of the temporary approval application fee that plants the flag. So the applicant that paid the fee first plants the flag first, and we begin the review of that record. Of course, if you submit the record, you pay the fee, and then DCR goes to review the application and you've uploaded a bunch of placeholder documents, that application is going to be deemed abandoned because you didn't submit the necessary forms and documents for us to review. If you submitted all of the necessary forms and documents for DCR to review, we would then review those documents. And if there's any documents that need to be fixed or cured or inconsistent, you would have the opportunity to fix it. If it's a phase 3 retail round 2 applicant, it's going to be a similar process. The phase 3 retail round 2 applicant is eligible for a fee waiver. So when the record is created and submitted, and we identify it as a phase 3 retail round 2 record and the fee waiver is applied, the fee waiver is applied to the date that the record was submitted. Then we would begin our review. Again, if placeholder documents are uploaded and it's not actually a complete application, it would be deemed abandoned and we would go on to the next application. So, if a phase 3 retail round 2 and a phase 3 retail round 1 applicant submitted temporary approval applications on the same day, most likely it's going to be the phase 3 retail round 2 applicant that would plant their flag first because of the fee waiver, and the unlikelihood that the phase 3 retail round 1 applicant had already scheduled an appointment with the Office of Finance to remit their fee. The key is the timing of the payment of the fees, and fee waivers inherently give a benefit because they're applied immediately. We don't have to wait for a payment to be submitted or processed by the Office of Finance.
Okay, our next question comes from Josh. What is an average timeline from temporary approval to annual licensure? And should we apply 6 months away from the time TA expires?
So we're going to be opening the annual licensing process up for the first time on Monday, May 1st. For businesses that are already in our pipeline, we're going to be working with the Excella team to generate annual application records for existing applicants and licensees. And then once we've generated the record based on your existing information, it would be up to the business to go ahead and start uploading the documents to their annual application record so we can start the review. For new businesses coming in that are not going to go through the temporary approval process, we've tried to engineer the annual licensing process to be similar to the revised temporary approval process with the reduced document requirement, plus the Form 4013, which is the environmental review document, because that's the document that's going to be most important for the environmental review, and then the environmental report that needs to be issued and adopted by the city before you can meet the state's annual application requirements, because they do require the adopted environmental document before you can have that complete state annual application. So with that in mind, we're really going to be pushing hard to have folks get all of the necessary docs in to complete the annual application process in as soon as possible, so that we can start forwarding final recommendations on annual licenses to either the director as the first level decision maker, or doing the public hearings and public notice for the license types that go before the Cannabis Regulation Commission. The goal is to get in as early as possible, and we'll get into this in a little bit more, but the annual licensing process, as the recommendations adopted by the City Council would articulate, are going to shift the final inspection and the check for building permits, fire permits, et cetera, until after we've made the determination to issue the annual license. And basically, after we've taken the discretionary action to issue the annual license, The final inspection will just be ministerial based on your ability to pass the final inspection after you've gotten your state annual license and you've demonstrated that you've complied with other permitting requirements. And building and safety is going to be the lead on clearing you for any necessary documents or permits that may be required as part of that process. And I'll get into that in a lot more detail as part of part 4 of today's presentation.
Jason, looking at the time, we have a few more questions. What would you like to do?
Let's go ahead and move those questions. Let's save those questions for the Q&A as part of part 4. And I'm confident that similar to completing part 3, we'll have the conversation, the presentation done a little bit earlier to give us the ability to answer any of the pre-submitted questions for part 4, plus loop back to any of the questions that we haven't gotten to here, as well as any new questions that come in for the annual application process.
Sounds good. Thanks, Jason.
So with that, we will be beginning part 4 of Licensing 101 right around 6 o'clock or 6:01. So for folks that are listening in and for the DCR staff members, this is your opportunity to get up, stretch your legs, run to the bathroom, get some water, and I'll talk to you in about 5 minutes. Thanks, everybody. Good evening, everybody. We will begin part 4 of Licensing 101 in just a minute, so please stay tuned. So good evening to anybody who's joining us for the first time tonight. My name is Jason Kleen. I'm an Assistant Executive Director with the Department of Cannabis Regulation. And thank you to everybody who's been with us for the last several hours. We're going to start covering part 4 of our Licensing 101 presentation. So welcome. As part of this module, we're going to go ahead and talk about the annual licensing process that will open up on Monday, May 1st of 2023. We will also be going over the California Environmental Quality Act and the local process for reviewing your environmental documents, which will lead us into a discussion of DCR Form 4013, which is our environmental review document. We'll talk briefly about using ZAMIS, which has information that you could utilize to fill out your 4013 form. We will talk about the equity share review, which will be important for phase 2 applicants that have not previously been required to go through the equity share review. You will have to go through that review before your annual license application is deemed complete. For Tier 3 phase 2 applicants, you will have to enter into a social equity agreement with the city prior to your annual application being deemed complete, and I'll share more information on that later. Then, of course, we'll have a brief discussion of the fees. I do want to highlight the fact that the city secured a significant grant from the state of California to help transition local applicants and licensees into annual licensure, and the local jurisdiction assistance grant has been providing fee waivers for the environmental review, and we will begin providing fee waivers for the annual application fees as we transition all of our existing applicants and licensees into the annual application process. So for the businesses that are in our pipeline, all businesses, general and social equity applicant, you will be eligible for the environmental review fee to cover the review of your Form 4013, as well as the annual application fees, which we discussed earlier. And then, of course, we'll continue to provide fee waivers for those 2 items utilizing the LJAG grant until we fully exhausted the funding from the grant. We do have sufficient funds right now to cover everybody currently in our pipeline, including the folks that are part of the phase 3 retail round 2. And monies have been earmarked for everybody who has submitted an application or been authorized to submit an application up through phase 3 retail round 2. And again, we will have some grant funding for new applicants and folks that come into the process at a later date, but we will cease providing fee waivers once those monies have been exhausted. We'll cover some of the SEP resources. Given the fact that annual licensure is a new process, this is something that Dr. Brown and her team will be starting to build out from scratch as we release information and procedures bulletins, as we release updated forms, and then as we as the licensing team start to work with her vendors on what these processes are and how the vendors can be of assistance to our social equity applicants. And then, of course, we'll briefly cover the state and DCR deadlines. We'll get into a little bit more conversation about like the operating and permits and the renewal of the temporary approval applications. And then we'll jump into the question and answer session. Again, this is just a brief overview of what activities we're accepting applications for. This will be exactly the same for the annual application process when it opens up on Monday, May 1st. New applicants will be able to apply for the non-volatile manufacturing license types, the distribution license types, the testing lab. Social equity individual applicants may be able to apply for non-storefront delivery, as well as the cultivation processor and nursery activities. And then phase 3 retail round 2 applicants, or the social equity individual applicants selected to participate in phase 3 retail round 2 that haven't already submitted their temporary approval application records will be able to submit their annual application for the retail storefront activity. For all existing applicants and licensees, so you either have a pending temporary approval application or you have a temporary approval, which is your temporary license, those folks will automatically be transitioned into the annual application process, and we'll be working with Excella to create your annual license record so that you can pursue annual licensure. And the core number for your record will remain the same. You'll just have you'll have a completely separate record for your annual license application. It'll have new suffixes which will differentiate it from the temporary approval process. For folks that have temporary approval, of course, you'll be able to continue to renew your temporary approval while you work towards annual licensure. And ultimately, once you qualify for and are issued your local operating permit on your annual license, you'll no longer have to renew your temporary approval. So we'll talk about that a little bit more in depth later on. So who's going to be affected by the transition to the annual licensing process? The simple answer is everybody. So our current license holders are going to have to transition to annual licensure, both at the local and state level, if they intend to continue operating after the state sunsets the ability to renew provisional licenses. For anybody who does not currently have a provisional license, you'll only be able to operate once you've received both your local annual license as well as your state annual license and met other permitting requirements. For folks that are in the application queue that are unable to get to temporary approval or who have their temporary approval application deemed abandoned and have to refile, you're going to have to go through the annual application process, especially if you are unable to get a provisional license prior to June 30th of this year from the state. For folks selected through phase 3 retail round 2 and the application lottery, you're going to ultimately need to go through the annual licensing process. For the 30 folks that have already started the application process, you'll be able to continue to pursue temporary approval. And if you're successful in getting your state provisional license by June 30th of 2023, DCR will be positioned to issue you temporary approval as well. And if you're unable to get your state provisional license, you'll have the ability to immediately focus your attention on your local annual license application, because you'll need to complete that process and get your annual license before you can meet the state's annual licensing requirements. And then, of course, for our existing legacy operators, the existing medical marijuana dispensaries that were allowed to, for a temporary period of time, operate in a non-compliant location, such as an MR zone, based on LAMC 10407, and then the limited grandfathering provided by LAMC 105. It'll be important for you to be able to complete your annual license and get your state annual license based on your existing location, because ultimately, if at a later date you decide to relocate to a compliant location, which you'll need to do before the sunset date of the grandfathering, it's going to be easier for you to relocate a state annual license, because the state, of course, does not allow for the relocation of provisional licenses, and you can no longer apply for a new provisional license. So it'll be important for you to go through this process so that, if you do need to move your annual license, the state has the ability to relocate an annual license and apply the environmental findings that were applied to the original license to the new proposed location potentially. So those are some important things. So additional information is going to be coming out of the department over the next several weeks. And all of that information that's been released will be available on DCR's website in early May 2023, if not sooner. There's going to be two different processes for businesses going through the annual licensing process. One set of processes are going to be directly tied to retail storefront and then micro business with on-site sales. This license type has to be approved by the Cannabis Regulation Commission. There's also different noticing and public hearing requirements. So that's what we're going to focus a little bit on first. So as folks know, after Phase 1, which was the existing medical marijuana dispensaries, Council had adopted a policy that limited applications for the Type 10 retail storefront activity to social equity applicants through January 1st of 2025. So our existing medical marijuana dispensaries and our social equity applicants that have received temporary approval are going to be prioritized for the retail storefront with on-site sales, because they will have to go through the additional steps and hearings in order to get through the Cannabis Regulation Commission. We have requested a complete list of the expiration dates for all licensees that'll happen on or after July 1st of this year. Beginning July 1st, the state will be requiring folks seeking to renew their provisional licenses. They'll need an updated environmental document. And in order to issue that document, you need to have submitted your Form 4013 to the department so that we can basically complete our environmental review, and we can post our draft environmental findings to the website for public comment. And once we've done that, we can issue you a letter that will then allow for you to provide evidence to the state to meet the updated requirements as part of the renewal for a state provisional license. For our non-retail and our delivery retail businesses, we'll also be prioritizing the review of any of the forms for applicants that will have state provisional licenses expire in early July, so that you can have the documentation ready, and we'll begin to issue those letters in May. But we do need to have a completed Form 4013 on file, and we need to be able to review that before we can issue you those letters. So if you haven't already submitted your 4013, get it into us as soon as possible. And again, once your annual license application has been established in early May, you'll have the opportunity to upload the Form 4013 directly to that record as well. So as we're reviewing applications, we have the ability to deny the issuance of an annual license with no hearing at any time during the application process. Ultimately, if DCR determines that the applicant is ineligible for annual licensure, we'll deny the application at the earliest possible state. You do have the ability to appeal the department's determination by going through the appeal process if we deny your annual application. Alternatively, within 90 days of the date that we send out the notice of complete application, we have to make a recommendation to the commission to issue an annual license. So effectively, if you've submitted all of the forms and documents necessary and you meet all of the requirements articulated within the code, within 90 days of DCR making that determination that your application is complete, which also includes completing the environmental review, we are required to make a recommendation to the commission. So there, certain activity types like retail storefront do require a stakeholder meeting, which is effectively a community meeting. The commission hearing that you're ultimately scheduled for does have to be publicly noticed. So there's different noticing and meeting requirements that we're folding into our internal operating timeline to try to get you to the first level decision maker as soon as possible. And as we move closer to the May launch of the annual application process, we're going to be providing more information on what those timelines look like. We're going to be accepting annual license applications from the following parties. Under current law, we couldn't even begin the environmental review until a business received temporary approval. So there's certain businesses, maybe a couple dozen, that have already submitted their 4013 forms. We've already waived the fees using the LJAG grants, and we've been doing the analysis, and we're going to be positioned to post the draft findings in early May for those applicants. And then there's hundreds of other businesses that have temporary approval that were eligible to submit the 4013 form and begin the environmental process that haven't done that. So again, everybody is going to be automatically routed into the annual licensing process. And you will have to upload your previously submitted 4013 form or your 4013 form for the first time so that we can begin that review and analysis, because it will be critical for you to get that analysis completed so that you can have a complete annual application locally, and we can post our draft findings to the DCR website so that we can give you the letter necessary to renew your state provisional license. And then, of course, anybody who has received a pre-application review record that was deemed eligible for further processing will be eligible to start submitting annual license applications on or after Monday, May 1st. So there may be some folks that want to continue to submit the temporary approval applications because they're in the state's pipeline to get a new provisional license. But for everybody else, it'll be to your benefit to just go directly into the annual licensing process and begin to submit everything necessary for an annual license. And then again, I just want to reiterate that the fee associated with reviewing the 4013 form, as well as the annual application fees, are going to be waived utilizing the LJAG grants. So the sooner you get your records submitted and you get the documents uploaded, the sooner we can apply the fee waiver to ensure that you get the fees waived, because we will be oversubscribed either later this year or early next year for the fee waiver programs. I anticipate that we're going to exhaust somewhere between 15 and 17 million of the $22 million we've been allotted just based on our existing pipeline once we get those annual license records created and people start to upload the documents and we start applying the fee waivers. 3 million of our monies are dedicated to the environmental review. So there's only going to be $2 to $4 million of application fee waivers that will be available beyond our existing pipeline. So this is one of those things where it's to your benefit to get in early so that you can get the fee waiver. And it's also to your benefit to get in early because you're going to have to get this annual license and get your adopted environmental document in order to get your state annual license. The code requires that the annual application fees be paid within 30 days. For everybody who is an early adopter of the annual license application process, you're not going to have to worry about this because your fees will be waived utilizing the LJAG. So I don't anticipate any of these annual license applications are going to be abandoned due to non-payment of fees because we will be applying those fee waivers. However, your annual license application can be deemed abandoned if you fail to submit the requested information, documents, and forms that are required as part of our process. One of the big changes that was recently adopted by council and will be reflected in an upcoming ordinance amendment is the establishment of an operating permit. So under the existing code, businesses were required to pass a final inspection and meet all of the permitting requirements before DCR could even issue the annual license. And, you know, a lot of businesses are either working with building and safety or the fire department or water and power or the public health department on the necessary permits that they have to pull. And that requiring people to meet those requirements before we can make a licensing determination. And those are things that are all outside of DCR's control and we have no say in, just prevents us from moving our process forward, and it negatively impacts the business's ability to apply for and meet the state's annual licensing requirements. So earlier this year, the city council adopted several recommendations to refine our annual licensing process. And one of the big pieces was giving DCR the authority to complete the review of the things that are under DCR's control and purview, be able to make the recommendation to the first level decision maker so that we could adopt the recommendation to issue a license and the environmental document associated with that discretionary action earlier in the process so that folks can meet the state annual licensing requirements earlier in the process. And then, of course, once you've been issued a local annual license, you have peace of mind that once you get your state annual license and you're able to meet those ministerial permitting requirements from those other agencies, you'll be eligible to request a final inspection. And if you pass your final inspection, DCR will issue the operating permit, which will allow for you to utilize your annual license. For businesses that hold an active temporary approval, you'll be able to continue to renew your temporary approval so that you can continue operating under that temporary approval while you work towards getting your state annual license, meeting the different permitting requirements necessary for a final inspection, and the issuance of an operating permit. So every business that has temporary approval will have two active records. One will be the temporary approval record, which will have to be renewed so that the business can continue operating. And then separately, you will have an annual license record, and you will be able to issue an annual license so that you can get your state annual license and then, you know, invest any monies on tenant improvements or anything else necessary to meet the ministerial permitting requirements required by building and safety, fire, DWP, the Department of Public Health, and others, after you have peace of mind that you've received your annual license. And then, of course, once you've got all of the necessary permits and licenses, you have the ability to request your final inspection. And then when you pass it, you get your operating permit. One of the big things is going to be other recommendations adopted by council are going to make it easier for you to relocate an annual license. And again, the state has a process that will allow for the easier transition of an annual license to a new location. So getting a local annual license and a state annual license will be beneficial to the business. Part of the amendments council adopted was allowing for the license to be sold separate and apart from the entity that it was issued to. That's one of the reasons why we've established this new operating permit. Think of the annual license as an asset that could be bought or sold. Once we've determined that the license can be transferred to another entity that meets whatever requirements have to be met, that entity has a license, but they're not going to be able to operate under that license until they are issued an operating permit. And that's the city's way of ensuring that the holder of the license has all of the necessary permits and licenses in order to lawfully operate. But the benefit to being able to use the annual license as collateral, which you haven't been able to do in the past because licenses were not transferable separate and apart from the entity that it was issued to, which is why when you requested an entity substitution, the entity that you were trying to substitute in had to submit a brand new application and go through the application process themselves and demonstrate that they meet the requirements to be licensed. And then you, as the existing licensee, would cancel your license in order for that other entity to receive their license. This process that council, or the recommendations that DCR put out there that council adopted, will make it easier for licenses to move between entities and for us to do those modifications, as well as allow for those licenses to move to different locations, and then for that business entity to move the license there and just have to meet the operating permit requirements to begin to operate at that location. So again, there are a number of substantial changes that the director worked with policymakers to push through, that she's been working on for almost a year now, that were adopted in February. And I do anticipate that ordinance will be released by the city attorney's office in the next month or so that we can get those amendments dumped into the municipal code and have them become law. For the operating permit, the licensee needs to pass a final inspection, which we discussed. They need to submit through the DCR licensing portal evidence of the necessary permits, licenses, and other authorizations required by law from, city, state, or other public agencies. The most common ones are going to be building permits or fire permits, public health permits, copy of your state annual license. You'll have to make sure that your certificate of occupancy matches with the activities that you're engaged in. Building and safety is the lead for that process. They also have a clearance process with other departments such as fire and DWP, so that when the certificate of occupancy is being updated, they're routing information to these other agencies to determine whether or not any permits are necessary to do that certificate of occupancy change. All businesses are going to need a permit from the Los Angeles County Department of Public Health. Any business that has on-site retail sales will additionally have to meet the emblem requirements articulated in the code, which also comes through the County Department of Public Health. And of course, you'll have to have your corresponding state license for each of your commercial cannabis activities issued by the Department of Cannabis Control. There's always been a lot of questions about CEQA and what the city has been doing to comply with CEQA. The city has worked really closely with the Department of Cannabis Control to ensure that local applicants and licensees have had the necessary local documents in order to keep moving along in the state's process. At the local level, the environmental document required under CEQA cannot be adopted separate and apart from the discretionary action, which is the issuance of the annual license. So under the original code, you had to get temporary approval for DCR to begin the environmental review. You had to complete the environmental review and then submit all of the necessary annual documents before we could make a determination of completeness. And then once we'd done that, we would have to invoice you and wait for you to pay the fees before we could start the formal annual application process and review. So the old process was not business friendly. It was not going to expedite the transition of provisional licensees to annual licensure. So again, the director worked with policymakers to streamline that process and make it more accessible by shifting some of the requirements around. The requirements are still ultimately going to be the requirements before people can operate under the annual license. However, the order of operation has been shifted so that DCR can focus on things that are under DCR's purview, including the environmental review document, and get those adopted by the first level decision makers so that you can meet the state's licensing requirements. And then, of course, once you've been issued your annual license application, if you're not already working with building and safety and fire and public health on the necessary permits, you should be, because they'll be required for that final inspection to get the operating permit. As I mentioned earlier, the submittal of the 4013 form is necessary for us to do our environmental review of your project. And for folks that are going to be renewing provisional licenses, you'll have to demonstrate progress towards your environmental compliance, and you'll have to get a letter from the city stating that we've drafted our environmental review document. And we can only do that if you've submitted your 4013 form and we've actually reviewed it and made a determination on what type of environmental document needs to be prepared. To date, all of the environmental documents I've reviewed, I believe, have qualified for a categorical exemption, and that is going to be part of the department's draft analysis. But again, I've only seen a few dozen of these forms come through, so I know that there's hundreds more that need to be submitted. And for folks that do have active provisional licenses, you will have to go through this local land use review in order for us to give you the document necessary for you to renew that provisional license. And the need for that document kicks in July 1st of 2023. So we've been in direct contact with all of the bureau chiefs up at the Department of Cannabis Control, and they're going to be providing us a list of when state provisional licenses are going to be expiring so that we could prioritize the review of the environmental documents necessary for folks that will be having their provisional licenses expire in July and August, so that we can make sure that you get the letter you need to renew your provisional license. We do need to have your 4013 on file, and it does need to be complete, and we do need to analyze it before we can issue that letter. So if you haven't already done so, get us that 4013 form if you have temporary approval, because we need to start reviewing it immediately. And there's no additional cost to submitting it us and having us do the review, because those fees are being waived through the local jurisdiction assistance grant. So please get it in. Now I'm going to go through the 4013 form. It's a project-specific information form. Effectively, it's giving us an overview of what your project is, what activities you're applying for, where your business premises is located, and whether or not you may qualify for a categorical exemption under CEQA. There's a lot of information tied to the assessor's parcel number, neighborhood council, the zoning, the specific plan area. All of this information is available on ZEMAS. And I know during the pre-application module, which was part 2 of today's presentation, I actually went into the live ZEMAS system and I showed the screens and where you can access that information. So if you missed that part, I would recommend reviewing it later on. And then just quickly, I'm gonna jump into it so you can see what that form looks like, or what the information in ZEMAS looks like and where you can find it. So within ZEMAS, I did have some of these tools popped up. When you type in a parcel location and you search by street number, street name, you'll get different information tied to the parcel. So the first address legal section will cover any of the addresses associated with the parcel. It'll have the assessor parcel number on it. The jurisdictional piece covers the community plan area, the neighborhood council, the council districts, etc. If you need to review any building permit issues, such as the certificate of occupancy, you can do that here too. It'll link you through. Then you've got different information associated with the specific plan area, which is down here. Community overlay zones. You've got information about, let's see. Your additional is going to have some of the different things that may impact the review of the parcel. So is it a farmland? Is it a hazard zone? Is it a coastal zone? Is it a flood zone? Is it a hazardous waste, border zone property, etc.? So these are things that you'll want to review so you can make sure incorporate it on your 4013 form. Your economic development area is going to have promise zones, opportunity zones, enterprise zones, the business improvement district, if any. You'll have information about whether or not it's subject to rent stabilization or anything else. We don't have rent stabilization for commercial properties in the city, so that most likely won't apply unless it's a mixed use building. And then of course, public safety is going to have the information related to the police department and the fire department that will help you fill out the form. So when we created the form, we worked with the state agencies to make sure it had the information we needed and the information that they needed our analysis to cover for their purposes. And we made sure that we could link the data sets that are requested here that the city has access to ZMIS so that you could pull this information directly, which will make it easier for you to fill out the forms. So hopping back into the presentation, folks all know that you can get this information all out of ZMIS. If you have questions, please feel free to reach out to DCR licensing at lacity.org or call us on the phone during our business hours. And we do have public counter hours on Mondays and Tuesdays from 10 a.m. to 3 p.m. So we're here to answer questions and assist you in getting you through this process. As I mentioned, I did jump over to a live version of the ZMIS to kind of walk people through the different categories. Here we've highlighted different subheaders for where you can find information to fill out the Form 4013. On the 4013 at the end of it, it does have a partial list of the different categorical exemptions and classes for those exemptions on the back. So if you believe that your project does lends itself to one of those categorical exemptions, you can go ahead and you can fill this out and you can put this information in. Even if you don't fill this section out, we'll be reviewing your project to determine if it does qualify for categorical exemptions. But it is always helpful if you, your consultant, the law firm that's providing you legal guidance takes a look at what exemptions may apply and you fill this out. Because it just gives us the ability to kind of hone in on specific things easier as part of our write-ups. When you fill out the form, you're going to identify where you're getting information. So ZMIS, the DCR licensing map, any documents or references you or your consultants may be utilizing, you can input that information there. You'll talk about the zoning and the surrounding land uses. You know, when you looked at ZMIS, it will show you in different colors what the different zones are. Pink is commercial, blue is manufacturing. I think residential is yellow, but don't quote me on that. But it has a table and a color scheme when you log in, and then you can kind of notate that within 700 feet or within 1,000 feet, these are the different types of uses. So a lot of the retail storefronts are in commercially zoned areas, or they're in manufacturing areas and they're engaged in other non-retail activities. But the zoning is correct, except for the grandfathered phase 1 businesses. And, you know, the project location and the types of things around that project location, at least directly adjacent to it, are typically the same types of zoning. You know, what's the general plan, the land use, the zoning, what activities are occurring outside. So, you know, all of our commercial cannabis activities have to occur indoors. But, you know, are you surrounded by commercial retail businesses? Is it a Best Buy? Is it a restaurant? What's next to you? What's down the street from you, et cetera? Really here, you're kind of describing what things are going on, including other businesses, And you may be demonstrating that other businesses right next to you are engaged in similar activities or the same activities that you are, which kind of lends itself to you're engaged in an activity that's appropriate for that location. Project size, you're going to want to talk about the square footage tied to the different activities. When we look at your premises diagrams, you're identifying where on the premises you're engaged in different licensed activities, how much of it is administrative or shared hallways, et cetera, but really focus on the floor area dedicated to a specific commercial cannabis activity. So for the folks that are engaged in cultivation that have stacked beds, what's the floor area of the room your stacked beds are in? I don't need the total cultivation space because that is most likely going to exceed the total floor area of your business premises identified for cultivation. You know, when you do your footprint and you're looking at your business premises diagram, the width times the length of the room for the activity is going to be your total floor area. Don't get involved with height. Don't get involved with doubling for stacked beds, et cetera. Focus on the total floor area and only the total floor area because you don't want to overstate what your footprint is for a particular activity as it relates to this form. Generally, for the Form 4013s that I've reviewed, it's been a non-issue. But if you do have, if you are vertically integrated, you do have a bunch of activities, you're utilizing the full extent of the medium cultivation license and stuff like that. Some of those are bigger facilities. And, when we start doing the mapping and stuff, because we're mapping from a larger footprint, the radius around the building and what properties it covers is significantly larger. So we want to be able to do the accurate analysis. So please just give us what we need, nothing more. Your hours of operations, how many employees do you have? How many trips do you think you're generating per day? Where do you get your water from? Most people get water from the Department of Water and Power. For wastewater treatment facilities, by and large, that should be the Department of Public Works, Bureau of Sanitation. You'll describe the characteristics around your project site, topographic features, natural characteristics. A lot of the stuff you can get in ZMIS, and you can kind of toggle between the different mapping layers, and then just write down a general identification of what's there. And you're also the applicant or licensees, so you know the surrounding area in your community, so you should be able to fill out these forms. And then, back here on page 7, you'll try to identify all of the permits that you're going to need. You will need licenses from the Department of Cannabis Control. You may or may not need permits from fire department or building and safety. Most of our businesses aren't going to have to get a permit from the California Department of Fish and Wildlife because they're not typed into any natural water source. Everybody's going to have to get a public health permit. You may or may not need anything from AQMD. Most people aren't dealing with anything where they would be affecting stream beds, so you won't need a stream bed alteration agreement. But again, we worked with the state on what the checklist could look like, and we threw everything at it. And building and safety is a resource as it comes to looking at the certificates of occupancy and whether or not you're going to have to change the occupancy, which could trigger the need for plan check review and additional permits. So you may want to reach out to them as well to make sure that your certificate of occupancy is consistent with the activities you're engaged in. And if not, which of these agencies are you going to have to reach out to get the permits or clearances necessary for them to update the certificate of occupancy? Because even though we don't need it for our process at this point to issue an annual license and make a recommendation, you will need to have all of that aligned in order to get your operating permit to operate on your annual license. And as I mentioned, there's a partial list of categorical exemptions. We just left the common ones that we've been seeing for the Form 4013s that we've reviewed to date. It doesn't mean that it's not an exhaustive list. There are a lot more class and category exemptions under CEQA. If you're working with a consultant or a law firm that has an expertise in CEQA, they can also direct you to other classes and categories that may qualify for that categorical exemption. Again, the social equity program is trying to promote equitable ownership and employment opportunities. There's a lot of resources that they put together to date based on the temporary approval process, the pre-application review process, et cetera. But Dr. B and her team are going to be working with my team on licensing to start to put together collateral materials and things for their vendors so that they can start putting out more collateral information through BLC, through the LMS system. We'll be working with LACPA to kind of update them on our processes. So I've got a meeting coming up with them so that their lawyers become aware of what this new process is going to look like. So that will hopefully help applicants that are participating in the low bono or the pro bono programs understand who they should be talking to before they enter into business agreements or what type of advice they should be getting, so that they can complete this process as quickly as possible. And then, of course, for our phase 2 applicants, were able to get temporary approval without either meeting the equity share requirements and going through the equity share review or executing the social equity agreement. Both of those things are required for the annual application process. So a tier 3 phase 2 applicant that has to enter into a social equity agreement with the city will have to submit that agreement and demonstrate that they've either complied with, are complying with, or will comply with their requirements to be a tier 3 applicant. And of course, our tier 1 and tier 2 phase 2 applicants who are bona fide social equity applicants will have to go through the equity share review before we can deem your annual application complete. So if you've got questions, if you're a phase 2 social equity applicant and you have questions about what your obligations are and what you have to do in order to meet the equity share provisions, the social equity team already has vendors and resources that identify that. And of course, they've got the one-on-one training assistance to help identify areas you can look at and answer questions. So even though some of the programming is going to be new and will be led by the DCR comms team and the licensing teams to begin with, as those materials are rolled out and as the municipal code is updated, Dr. B will be working directly with her vendors to get out as much program as possible as soon as possible, and then update the LMS system to provide those additional resources. And then, of course, I talked about the need to meet the equity share requirements for phase 3, round 1 and on. We've been doing that equity share review before we issue temporary approval. So the folks that are in our pipeline have already been working with somebody on the equity share review. It's been completed, or they're working on getting it completed. For the application fees for the environmental review and annual application processes, as I mentioned, the LJAG grant will be providing fee waivers for the review of the Form 4013. Hopefully that will result in the identification of a categorical exemption for your application record. And then, of course, your annual application fee, which is a fee per activity, is also being waived utilizing those LJAGs. So as we transition and establish the annual licensing application records, we will be applying those fee waivers for all of our existing applicants and licensees. And you won't have any out-of-pocket expenses directly tied to the environmental review for categorical exemption or the annual application, at least initially. But because you are receiving these fee waivers, please make sure that your documents are complete so that when we do the review, we don't have corrections or have to charge a la carte fees to have you resubmit and for DCR staff to re-review it. Because if you do get all of your ducks in a row, you make sure that everything is complete and it's concise, you won't have to pay any additional fees to get into and navigate out of this annual application process. I already covered what types of assistance is available. The deadlines are still all the same. The state only has until June 30th, 2023 to issue new provisional licenses. They're going to be allowing existing provisional licensees to continue to renew as long as you can meet the evolving environmental documentation, which does require the submission and review of Form 4013. So if you have your provisional license expiring in July or August, please make sure you've submitted your 4013 form so that we can get it reviewed so you can get your letter from us. And then of course, after July 31st, any new application filed, whether it's a general applicant, a social equity applicant, a refiled application, will have to come in as an annual application. And until we've exhausted all of the grant monies providing the fee waivers, we still will be providing fee waivers. So for folks thinking about refiling that are not in a position to get your state provisional, you may just want to wait until May so that you can refile as an annual application and be eligible for those fee waivers from the LJAG grant. And then of course, for folks that are unable to get temporary approval or the provisional licenses, we'll already be creating your annual licensing application record. So if you aren't in a position to move forward with your temporary approval record, you could just go ahead and withdraw or abandon or cancel it and just focus solely on your annual application record, because that's really what you're going to need on a go-forward basis to meet the state's licensing requirements. Here are just some links again to the State Department of Cannabis Control's resources. And I know we're going to be running out of time, and I don't know how many questions we have. Gidget, if you've been tracking the questions, how are we doing?
So we have about 6 questions.
Are you good to just power through and skip the break?
I'm fine if you're okay.
I'm okay.
Okay. Let's go ahead and start with Anita M. What happens to an SCIA who are eligible to apply for a LA cannabis license but have not applied yet due to financial reasons, yet they still want to apply soon?
So verified social equity individual applicants still have the opportunity to submit a temporary approval application through July 31st of 2023. The temporary approval is really only going to be helpful if you're able to get a state provisional license, because you need both the state provisional plus the temporary approval, plus you need to meet the permitting requirements in order to lawfully operate. So if you can't get your state provisional license, temporary approval doesn't mean anything. And in order to get your annual license from the state, you're going to have a local annual license, and you'll have to have a completed environmental review document. So if you are a phase 3 retail round 2 applicant, the ordinance gives you up to 1 year to complete the pre-application review process. And of course, if you submit a compliant location that's deemed eligible for further processing, you get an additional year to file your application. If you have a pending temporary approval application that is later deemed abandoned or has already been deemed abandoned, the current code gives you up to 1 year to refile. And refiled records, again, start with the pre-application review process. And if that pre-application review record is deemed eligible for further processing, you have an additional year to submit your application. One of the recommendations council adopted earlier was to extend the refiling period from 1 year to 3 years, and then also allow licensees who allowed their licenses to expire to refile. So that was all done with the director's intention of giving people more time to find compliant locations, make necessary business decisions, raise capital, look for partners, do other things. So the director has really been cognizant about trying to give people as much time as possible to comply. And thankfully, policymakers adopted a lot of those DCR recommendations And as soon as they have the opportunity to review the draft ordinance and adopt the draft ordinance, those changes will start to become local law. So there's a lot of things moving. If you can't get temporary approval, you can't get a provisional. We've tried to make the process for the annual license as streamlined as simple as possible before you actually have to secure a location or potentially incur any costs associated with tenant build-outs or other permitting activities.
Thanks, Jason. This next question has a few details, so if you need me to repeat it, please let me know. This one comes from Mary Jane. When making a request for modification, in this case, an ownership removal, the entity has 2 licenses at one location and 1 license at another location, all owned by the same entity. Do we submit one form with all the license numbers listed to the LBER, or do we submit one form for each license as a merged document?
So say hi to Peter Parker and Spider-Man for me. And so one of the big purposes of creating the legal business entity record is so that all of the ownership and operating related information was on one record. And then that record would be the parent of the application and licensing records, which are location specific. So if you've already created your LBER, you would just submit one modification request against your LBER. And then once we've approved that change, then those changes will be pushed down to any pending applications or licenses that have been issued so that your ownership is consistent across all of your locations and all of your activities. So the answer is one modification would be submitted against the LBER, and that would cover all of your pending applications as well as any locations that have been licensed.
Thank you, Jason. Our next question comes from Edwin A. He's having trouble finding a property that is far away from a sensitive use. Are there any resources you can provide to help us identify a suitable location for a retail location?
The big tools are going to be the DCR licensing map, as well as the zoning information map access system. And links are in this presentation, and I've kind of walked through a few of the tools and the things to toggle on and off to help you find a compliant property. But we don't have a list of compliant properties, nor do we have a list of landlords that may be willing to lease to a commercial cannabis business that you could look at. The director is aware that a lot of social equity applicants have made it known that it's difficult to find a compliant property. And even when you do find a compliant property, finding a landlord that's willing to lease to you has been difficult. So there are some additional policy considerations that the council will be taking up, hopefully in the next few months, that may give us an idea of whether or not we could see change on the land use side. And of course, the land use side and the administration of LAMC 105 and any change to that section of the municipal code, the Department of City Planning is the lead. So we would have to propose amendments, council would have to support those amendments, and then they would have to direct the Department of City Planning to prepare and present the necessary documents to effectuate those changes. And having gone through that just to get LAMC 105 updated to clearly define the sensitive uses and when flags get planted and everything else, which we started back in 2018, it took about 2.5 years to get through that legislative process. So I don't know if it could be done faster, but once the ball gets rolling on it, it's unfortunately outside of DCR's control.
Our next question from Katie. How long are TA holders exempt from needing an operating permit in order to operate?
So we've designed our local process to allow for a temporary approval to be renewed through the 2027 license year. So no later than January 1st of 2028 would you have to have an operating permit in order to utilize your local annual license. We set it out so far, beyond what the state was doing, with the knowledge that, the state doesn't have all of the local requirements as part of their process that we do. And our goal is to get you to a decision point that's under DCR's control so that you can get to a decision point that's under the DCC's control. And then you can work with all of these other agencies that don't take input from DCR, nor do they report to DCR, to get your necessary permits. So we do encourage folks to start meeting with those departments as soon as necessary. And the Form 4813 does identify a number of the agencies you may need to get a permit or a license from in order to lawfully operate and meet the requirements for a final inspection to get your operating permit. If you ask the legacy operators and the phase 3 retail round 1 folks, nobody anticipated that there was going to be a global pandemic in 2020 where departments stopped providing in-person services and things transitioned to virtual services, and there was an inability to get supplies for a number of months, if not years. There were staffing shortages and everything else. So at the earliest point you can get into a process and start to inquire what you need so that you can have everything you need to qualify for the operating permit, you really should be doing it, because we're not going to be able to further extend these timelines, due to unforeseen consequences. So 2027 is the last year a temporary approval will be issued for. By January 1st, 2028, you need to have an operating permit if you want to be able to use your annual license.
Jason, I'm just checking the time. It's 7 o'clock. I think we have about 5 questions to go. Are you good?
I'm good if you are.
I am. Okay. So the next question from Katie: can a existing medical marijuana dispensary that is not an SEA renew with the state this upcoming summer if a 4013 has not been submitted to DCR?
No. So the state's requirement to renew a provisional license is a requirement for all applicants to demonstrate that their local agency has completed the initial environmental review, and we need a submitted 4013, and we need to analyze it before we can make that determination. Again, only a few dozen of these 4013s have been submitted. All of the ones that I've personally reviewed have qualified, in my mind, have qualified for a categorical exemption, and that is the draft recommendation for the department, which would go out for public comment. And once we start posting those for public comment, which we'll begin to do in May, so that folks can start getting their letters to renew after July 1st, that satisfies the state's enhanced requirement for the renewal of a provisional license. But it applies to general applicants and social equity applicants.
Rick has a question about Form 4013, specifically item 7. Do we have to submit with Form 4013 all of those items listed? I don't know if you recall what item 7 is.
Sorry, I apologize. I was talking on mute. I pulled up the 4013 form so we can walk through it together. This is a list of other federal, state, or local permits that may be required. Everybody is going to have to get a license from the Department of Cannabis Control, so that should be checked. Depending on your activities, you may or may not need to get anything from fire department or building and safety, water and power, or the Bureau of Sanitation. I would recommend reaching out first to the Department of Building and Safety based on the certificate of occupancy to find out, based on the activities you're engaged in, whether or not you're going to have to update your certificate of occupancy. If you do have to update your certificate of occupancy as part of that process, you're going to have to submit for a plan site review, and there will be a clearance process where the Department of Building and Safety will require you to get clearances from Water and Power, Fire Department, Public Health, et cetera, where they have an opportunity to identify whether or not a permit would need to be issued before they'll give the clearance to Building and Safety to update the certificate of occupancy. For the Department of Fish and Wildlife, I haven't seen any projects that would require a permit from them. There's not any projects to my knowledge that affect any stream beds or anything else. For the State Water Resources Control Board, again, all of our water goes through the Department of Water and Power, and I don't think I've seen anything that I have not personally seen anything that has required anything from the State Water Resources Control Board. Every business is going to be required to have a public health permit, so that should be checked for all of them. For the local air district, which is AQMD, I haven't seen anything come through with that. Stream bed alteration, I haven't seen anything come through with that. The water quality protection program, I haven't seen anything come through with that. But I have seen things come through with the city agencies, especially for folks working through changes to their certificate of occupancy. And again, for those types of changes, Building and Safety is the lead, and they have their own routing and clearance process to do those updates. So if you have questions about whether or not you're going to have to amend your certificate of occupancy, Building and Safety is the place to send that inquiry.
Okay, our next question from Katie. How does a TA holder know that their 4013 has been reviewed and approved by ZCR in order to get sufficient documentation to submit to DCC?
So we're going to begin to upload our draft environmental documents in May. So if you haven't seen your draft environmental document be uploaded by June 1st, I would inquire with the DCR. Again, we have requested a list of expiring provisional licenses for July and August, so that we can prioritize the review of the 4013 forms for those businesses so that they can get the letter they need to renew their provisional license. Otherwise, we're just processing things in the order received. But there are hundreds of businesses that are probably going to need to renew their provisional license over the next 6 to 12 months that have not submitted their 4013 form, that are going to be competing with everybody else that is now submitting the 4013 form as part of the annual application process, or they need to renew their state provisional license. So again, we have fee waiver monies available for doing the 4013 review. And it's just a matter of you getting the form completed and getting it into us so that we can begin the review and we can get you what you need to comply with the state.
Here's a question from Josh. For entities with temporary approval received, is there a way to file extension for the TA not to expire while the annual license is being applied and reviewed?
I'm not 100% clear on the question, but the temporary approval record and the annual license record are two separate records. And they both live on their own. So if you've received temporary approval, you'll have the ability to continue to renew your temporary approval on your temporary approval record through the end of 2027. So you could you can continue to renew your temporary approval and have it be operable through December 31st, 2027. That should give you sufficient time to work through the annual license application process, receive an annual license, get your state license, and then begin to get the any permits needed to do the final inspection and get your operating permit to utilize your annual license. For folks that get into the annual licensing process that have provisional licenses, continue to renew that temporary approval until you get that operating permit so that you can continue to operate, of course. And hopefully that provides enough information to answer the question.
Okay, and then our final question comes from Katie. Will DCR immediately revoke TA and notify DCC in order for the operator to be forced to shut down if an operating permit is not obtained by the deadline?
I don't, so it may be a semantics question, but there are certain reasons why DCR could suspend or revoke temporary approval or an annual license, and those are kind of articulated in the code. But if the operator fails to timely get an operating permit, that means that they didn't get an operating permit by January 1st of 2028, or they failed to timely renew their temporary approval, and their temporary approval just expired because they're only valid for a year to begin with. So we do share lists and information with the DCC on a periodic basis. And, a business that doesn't have an active license or an active application is not going to appear on that list. And when DCC reconciles the local data against their databases, they will identify operators that don't have a local license or authority to operate. And that could, ultimately result in some other type of enforcement action being taken against the operator. But we typically, we have not taken an action to revoke temporary approval as part of a disciplinary action against a business yet. And we wouldn't notify the state of a revocation for a disciplinary action until we knew whether or not the operator was appealing that decision and the adjudication of that appeal. Because we've had instances where the state's notified us that they've revoked a provisional license, and then we've started to take actions to revoke the temporary approval. And by the time we get to a hearing, the person has come into compliance with metric, or they've basically made any outstanding tax obligations. They've brought their tax account current, and then the state immediately reinstates their license. And now you have the license. So the reason we were seeking to suspend or revoke your temporary approval is now a non-issue. So now we kind of wait a little bit longer before we initiate those proceedings to make sure that the decision is final, so that both parties can move forward appropriately.
And that is the last question. Thank you so much, Jason.
Thank you so much for hanging out with me for the last 4.5 or 5 hours. And, thank you everybody for tuning in today. This presentation and the additional materials are going to be made available next Monday. So our systems analyst will be working on getting everything rendered and putting in the chapters in so folks can jump to different points of the presentation. That'll be available on the website with the PowerPoint presentation. And as I mentioned, we'll be launching the annual licensing process on Monday, May 1st. So that there's going to be a lot more updates and information posted as it relates to that process over the next coming weeks. So thank you everybody for tuning in today. I hope everybody has a wonderful weekend, and I look forward to our next webinar. Good night.